afternoon, and I hope you'll be with us throughout. But I'm going to be chairing this seminar or webinar, and I'll be giving two of the talks. Now, there has been a slight change to the program in that I'll be followed at 10 to 11 by Samina Iqbal. She's changed places with Nishan Paramjorthy, who'll be filling her slot later on at 35 minutes past 12. Now, I'm kicking off with a talk entitled More Changes to the Immigration Rules. And it's a bit of a mishmash, but I hope there'll be something of interest to everybody. And first of all, just some initial remarks about the current state of the immigration rules. It's really in a state of flux because for quite a long time now, a Home Office task force has been trawling through HC 395 and rearranging and rewording, first of all, the points-based system. And since then, it's been moving on to other aspects of the rules. And really, the next big change will be the family migration and private life rules. So things like Appendix FM and paragraph 276 ADE. But that probably won't happen until at least spring of next year. So I'd just like to mention a few of the features of what's been happening so far. Well, lots and lots of sections of the immigration rules have been revised. And once they're revised, they're shunted off to the back of the immigration rules as appendices. And there are now more appendices than there are of the main body of the rules themselves. And not only do you have large sections, things like Appendix Skilled Worker or Appendix Student, which are relevant to many thousands of people, but you have other bits added on which contain information relevant to the main categories. So you've got Appendix Skilled Worker, the replacement for Tier 2 General, followed by things like Appendage Shortage Occupations List and Appendix Skilled Occupations. And as you'll see from the brochure, Appendix Shortage Occupations sets out the skilled jobs that the Migration Advisory Committee has said ought to be filled by migrants. And then Appendix Skilled Occupations, which is the skilled jobs which can actually be done by sponsored workers. So we've got a very recent batch of changes in HC, I should say, HC 617, which was published only on the 21st of September. So it's still pretty new. I'd like to go back a bit to something that happened in December last year, but perhaps hasn't sunk in as much as it should. And certainly I didn't pay it too much attention at the time, but it's the new Part 9 of the immigration rules, which has replaced the previous Part 9, the general grounds for refusal. It's now called just grounds of refusal. And it fuses the different paragraphs 320, 321, 322, 323. They're all now listed according to a numbering that begins with 9.1 and goes on up the scale. So it's not divided up into refusal of leave to enter, refusal of leave to remain, and so on, but rather it's the kind of reasons for the refusal. Now, it takes a bit of getting used to because some of the reasons for refusal or grounds for refusal which used to be mandatory are now discretionary, and the other way around. Some discretionary grounds have become mandatory. One thing in particular which caught my eye was the old paragraph 320, subparagraph 11. Now, that was one of the few subparagraphs of paragraph 320 which applied to Appendix FM and paragraph 276 ADE. So it was mandatory and discretionary grounds for refusing entry clearance and leave to enter. But most of it didn't affect applicants for entry clearance to join family members in the UK. But one particular subparagraph did, and that was subparagraph 11. Now, that talked about, and you'll see this on the third paragraph of my course notes, it was a discretionary ground for refusing entry clearance or leave to enter where the applicant has previously contrived in a significant way to frustrate the intentions of the rules. Now, that was then specified. What does it mean to contrive in a significant way to frustrate the intentions of the rules? And it's by being an overstayer, breaching a condition, being an illegal entrant, or using deception in a previous application. So that's what it means. But there was more to it than that. There had to be more than just frustrating the intentions. There had to be other aggravating circumstances. And examples of those are given. Things like absconding, failing to answer to bail, and so forth. Now, the present version of this in Part 9 is quite different. It says at paragraph 0.8.2, an application for entry clearance or permission to enter. Note that leave is now generally replaced by permission in the new immigration rules, may be refused where the applicant has previously breached immigration laws and, it goes on, it doesn't specify what breaching the immigration laws means in this particular subparagraph, but it does say a couple of subparagraphs further down, and it's the same list of things: overstaying, breaching a condition, being an illegal entrant, and using deception in a previous application. So just to go back, the applicant has previously breached immigration laws and has previously contrived in a significant way to frustrate the intention of the rules. Intention here is singular. Apparently, there's only one intention rather than intentions as previously. So those breaches are not themselves contriving to frustrate the intention of the rules. So what does that mean? Well, it goes on, frustrating the intention of the rules, or there are other aggravating circumstances in addition to the immigration breach, such as failure to cooperate with the redocumentation process, using a false identity, or a failure to comply with enforcement processes, such as failing to report or absconding. So that leaves previously contriving to frustrate the intention of the rules. What is that? It's not breaching immigration laws, such as being an overstayer, nor is it doing things like failing to report, absconding, and using a false identity. So what exactly does it mean now to contrive in a significant way to frustrate the intention of the rules? So we'll have to wait for a case to come before the upper tribunal, I suppose, to find out. Next comes a little section entitled Developments and New Legislation. Well, there is new legislation proceeding through Parliament at the moment, which is the Nationality and Borders Bill. That's attracted quite a lot of attention and a lot of criticism, for what it says about asylum. The intention of the bill is to make a clear distinction between people who come to the UK by lawful means, namely through settlement schemes, rather than people who come to the UK to claim asylum using people smugglers, human traffickers, or coming indeed under their own steam, but with false papers, or even coming in on the back of a lorry. So asylum seekers who come to the UK illegally are to be treated less favorably than those who come to the UK lawfully. Sorry about my slipping up there. There was a ring on the doorbell. I think that's the postman, but I shall carry on. I was saying about asylum seekers who come here unlawfully. They are to be treated less favorably than those who, well, would you excuse me? I'd better just see who this is. So I'm just going to mute, and I'll be back very shortly. I'm very sorry. I'm very sorry, ladies and gentlemen. That was the postman. This is the trouble with Zooming from home. It's not like going to the office or going to a lecture theatre, as we used to do for AstenJ training. Anyway, if I can pick up the threads of what I was saying, the main thrust of the Nationality and Borders Bill is to do with asylum, and it's attracted a lot of favorable comment, I suppose, in the tabloid press, but adverse criticism from people working in the immigration and asylum sphere, who greatly deplore the distinction between asylum seekers who come here illegally with false papers or in dinghies crossing the channel, and those who are brought to the UK through settlement schemes, such as the one which has been operating for Syrian refugees in displaced persons camps outside Syria mostly, and now the scheme for Afghans, which I'll be coming to later. Of course, the greatest attention has focused upon people crossing the Channel from France on dinghies, and there are provisions in the bill for such people to be turned back by border force or immigration officers. But I'm not going to say any more about that because it's still going through Parliament and we don't know exactly what bits might not get through, though with a large Conservative majority, we can expect that most of it will get through. Anyway, something I would like to just say a little bit more about is the national referral mechanism and the way that people who claim to be victims of human trafficking are treated. Now, the government thinks that a lot of the people who make such claims are not genuine, and they want to tighten up on the way in which people are to be regarded as genuine victims of human trafficking. So we've had for quite a long time the national referral mechanism, part of the Home Office, which investigates claims and which can make a reasonable grounds decision that it's more likely than not that the person is a victim. And if that person is fortunate enough, there will be a conclusive decision that he is such a victim. Now, at the moment, if you do get a conclusive grounds decision from the national referral mechanism, you will most often have also made an asylum claim. You can't go back because you could be, again, apprehended by the people who trafficked you earlier. You could be re-trafficked. So you would not be safe going back. Now, at present, if you're in this situation, you've got a conclusive grounds decision, but you haven't yet got a decision on your asylum claim, you're in limbo. you don't have leave to remain. Mostly you're not allowed to work, so you have difficulty maintaining yourself. Well, there's been a recent decision in the administrative court finding that this is contrary to the Convention Against Human Trafficking, which is not part of our domestic law, but the policy of the Home Office purports to be compliant with this international convention. And it's been held by the High Court that this obliges the Home Office to provide people who've been found to be victims of trafficking with leave to remain pending the outcome of their asylum claims. So that would be a big benefit for them. Now, what I'm going to talk about next is also contained in the Nationality and Immigration Bill, but it doesn't feature prominently, sorry, Nationality and Borders Bill, but it doesn't feature prominently in that bill. And this is correcting some anomalies or historical injustices that still remain in the British Nationality Act, 1981. One may be a bit more significant because more people are aware of it and it's been used more in recent years. And this is a provision contained in Schedule 2 of the 1981 Act. And it's one of the measures taken to prevent statelessness. And it's been there for a very long time. But as I say, only perhaps coming to many people's attention in recent years. And it provides that people who are born in the United Kingdom, but who are stateless, may, once they've resided in the UK for 5 years, apply to be registered as British citizens. It's an entitlement. And it occurs most frequently. It could happen any time until a person reaches the age of 22, but it most often happens when a child is born here and after its 5th birthday, it qualifies for registration. Now, this will most often be the case where there are parents in the United Kingdom who are not British and not settled, because if they were, any children born to them would be British themselves. There are people who are here with limited leave, or even here without leave, and whose children don't automatically acquire the nationality of their parents, because the parents have to do something more than just give birth to children in another country. They have to do something to register the children. So unlike British immigration law, in which someone who is British otherwise than by descent, who has a child born overseas, that child is automatically British by descent. Nothing has to be done to register the child. That's different in quite a lot of other countries. So your child, if born in the UK, will not automatically acquire your citizenship. You have to register that child with the embassy or High Commission in the UK. Very often, the parents involved have been Indian citizens whose children born in the UK are not Indian by birth from their parents. Now, they could be registered with the Indian High Commission, but if the parents don't do that, then the children are stateless. And there's a case I've mentioned here called McKee. That was Mr. Ockleton sitting as a deputy High Court judge in 2017 and hearing the case, and the Home Office argument was that, well, this is taking unfair advantage. These parents could easily get their child registered if they really tried. So we shouldn't allow this loophole to be available to parents who are contriving to get British citizenship for their children by the back door, if you like. And Mr. Ockleton, oh, well, his lordship, as he was sitting in the High Court, said, well, it's too bad if the law provides a loophole. There it is. If the child is stateless and has lived in the UK for 5 years, it is entitled to be registered. And if the Home Office don't like that, they have to do something about the law, about the legislation. So that is being changed, and the new bill will put children who are stateless and currently entitled to register as British on an equal footing with what it says about stateless children in the immigration rules. So paragraph 403, subparagraph F, says that efforts have to be made to get the stateless child the nationality of its parents or one of the parents. Otherwise, the child will not be eligible for leave to remain as a stateless child. Now, coming on to something which, in fact, I hesitate to talk about because I'm going to be followed by an expert in this field, Samina Iqbal. And I've actually contrived to repeat this section of my current talk with what's coming up later, an update on immigration law. I didn't really mean to do that, must have been a senior moment, but this is repeated, in fact, if in the talk later on this afternoon. And if Samina doesn't cover this, I can talk about it then, but I won't do that now, save to make a confession. I've got something wrong. Now, there's a paragraph just above where it says extended family members, where I think I've definitely got it wrong. And it says, special provision has been made for family members to join EEA nationals who have achieved settled status, and then to apply for the settlement scheme themselves, provided the relationship already existed before the end of 2020, except for children born to EEA nationals or their partners subsequently. Well, that bit's correct. But what about joining EEA nationals who have achieved settled status? What about pre-settled status? Well, I go on. Relatives wanting to come on a long-term basis and live with EEA nationals who only have limited leave to remain, in the sense of pre-settled status, will have to apply under Appendix FM. See Gen. 1.1.1 and Gen. 1.1.3d. Well, it's correct that there is provision in Appendix FM for family members to join EEA nationals who only have pre-settled status, but that doesn't mean that they can't join EEA nationals with pre-settled status under the settlement scheme. I hope that Samina can clarify why it is that there appear to be two ways for family members to join EEA nationals in the UK. One is under the settlement scheme and the other is under Appendix FM, which is of course a lot harder and costs money, unlike the settlement scheme. So anyway, I'll leave that with Samina and I hope she can come back to that. So I shall skip over this lengthy bit about extended family members and come next to the points-based system. Now, that has undergone quite a transformation. The tiers have been abolished. The only remnants of the old tiers are Tier 1 investor. In fact, that's the only category left in Tier 1. Oh, apart from the residual Tier 1 entrepreneur, which is still available for people applying to settle in the UK. Tier 2, the only survivor is T2, because there was a period when tiers became just the initial letter T, T2, Minister of Religion. Tier 5, subsequently T5, has gone altogether. Well, there was T2, sportsperson, formerly Tier 2 sportsperson, and now by virtue of HC 617 last month, that too has been rebranded. In fact, there is now an amalgam of the old Tier 2 sportsperson and the sporting bit of T5, creative and sporting worker. The sporting bit has been amalgamated with the sportsperson bit from the old T2 to create a new international sportsperson route. Now, there still is a difference between what used to be in the sporting route of Tier 5, because if you are an elite sportsperson wanting to come to the UK for just a short time, maybe just one season, you can get up to 12 months without needing to show that you've got English language at level A1, the basic level for people entering the UK who need to show English language, some kind of not competence, but basic English. So for people coming for just maybe one season, they don't have to worry about English language, but they still will need endorsement by a sports governing body, and they will still need a certificate of sponsorship from a club. And there's the £1,270 for maintenance needed, unless their sponsor is going to pay for their maintenance during the first month. So it isn't a huge change. Going on to appendix student, well, there is an addition, another new appendix coming after appendix student, which actually has been around for quite a few months now, and that is appendix graduate. It started in July. And this is a scheme whereby overseas students who have completed a degree at bachelor's or master's level at a UK university can stay on for another 2 years. If they've achieved a PhD, they can stay for 3 years. And it's really a very generous provision, because they are able to work or be self-employed without, well, certainly for employment, without needing a licensed sponsor. They just need to find any employer, and they can do any kind of work, not necessarily skilled work. So that is very reminiscent of a previous scheme, which came into being with the introduction of the points-based system way back in 2008. And this was the idea of post-study work, whereby if you had graduated from a British university, you could even do it with simply a diploma or certificate rather than a BA or an MA degree. You could then stay on in the UK for another 2 years to do any kind of work, and hopefully to apply then for the T2 general category of skilled worker, or else to set yourself up as an entrepreneur. Now, that didn't work. The post-study work route was closed to new entrants in April 2012 because too many had been ending up with low-skilled work, flipping burgers or filling supermarket shelves. So will this new graduate scheme suffer the same fate? Anyway, it should prove quite popular. Something else which is worth mentioning is that it's no longer necessary for one to have got an actual university degree, because provision has been made for those who have got a professional qualification at something which is recognized as being the equivalent of a university degree. Now, that was long the case, for example, with UK NARIC, which regarded the professional qualifications for accountancy, such as the ACCE, that's the the Chartered Association of Certified Accountants. I think that's the full title of that particular branch of accountancy. The ACCA qualification is actually much harder to get than most university degrees. There's a much higher failure rate. But although UK NARIC regarded it as equivalent to a degree, the Home Office didn't. But now the Home Office has seen sense and does include that within the qualifications which can lead to the graduate route. By the way, UK NARIC has now been renamed because apparently the NARIC bit is only for use in member states of the European Union, and it's been replaced by ENIC, the European, still European, Network Information Center. But just to make it even more confusing, this service is provided through an outfit called ECTIS, and in the rules, reference is made to ECTIS rather than to UK ENIC. Well, that's not very interesting, is it? I'm now going to come on to the old T5 temporary worker routes. Now, this still maintained the structure of the old Tier 5, in which beneath that overarching designation, you had lots of different ways of coming to the UK for short periods of 1 or 2 years for temporary work or indeed training. And now this overarching structure has been abolished, and the various routes that had been under it are now just separate routes, but they're all prefixed by temporary work. It's just that they're not all under a single tier. So take the example of Tier 5 temporary work, Youth Mobility Scheme, quite a mouthful. Well, that's now been abbreviated to simply Youth Mobility Scheme. Now, it's still got exactly the same provisions as before. A couple of new countries have been added. One of them is India, one of them is Iceland, and Iceland, pretty small country, now joins 2 even smaller countries, Monaco and San Marino, which were already in the Youth Mobility Scheme. Now, Icelanders aged between 18 and 30 can apply for up to 1,000 places on the scheme. But India, with a population vastly greater, only has 3,000 places allotted to it. And those who apply will be essentially in a lottery. The Home Office is expecting far more than 3,000 applicants. Actually, some of you may go back far enough to the 1990s when what used to be the working holiday scheme for young Commonwealth citizens started attracting applicants from the new Commonwealth. Traditionally, it had been mostly Australians, New Zealanders, and Canadians who applied for it, but towards the end of the 1990s, a lot of applicants started coming from India and Pakistan and West Africa, and they very often got refused on the basis that they weren't intending to have a working holiday, but were coming to work full time. Well, funnily enough, the replacement Youth Mobility Scheme permits you to work all the time if you want to during your 2 years. You don't have to spend half of it backpacking around the country. You can work the whole time if you want. Interestingly, though, for the first time, one of the countries whose youngsters can come here under the scheme have to have a certain level of education. So as we see, a qualification equal to or above regulated qualifications framework level 6, namely degree level, and they must provide written confirmation about that from the institution which awarded their degree. Alternatively, they can adduce evidence that they've spent a minimum of 3 years work experience in a professional role. Well, that's never been demanded of any country before, but it is being required of Indian applicants. Now, I'll be saying a bit more about that in just a minute, because my next bit will be talking about other temporary worker migrants, and all the routes have now been renamed. So, for example, Appendix temporary work, creative worker. That's what's left after sporting worker was hived off to international sportsperson. Now, what's been much in the news lately is temporary work, seasonal worker, because this was a pilot scheme only for the edible horticultural sector, and up to 30,000 foreign workers could come for up to 6 months only in any 12-month period to pick fruit and vegetables. So it was largely a summer and autumn seasonal job. They had to be sponsored, but not by the individual farmers or market gardeners for whom they would be working. They would actually be sponsored by an agency. And the official name for that was a scheme operator. And I think there were 4 agencies for edible horticulture. Now, there was a brouhaha in the last few weeks about garages running out of petrol and supermarkets running out of food and other necessaries for lack of lorry drivers. So the government said they were going to try and plug the gap by temporarily granting visas to foreign haulage drivers. Then it turned out that there was a shortage of poultry production workers. There weren't going to be enough turkeys for Christmas if this situation was allowed to continue. So the government said, okay, we'll issue visas to foreign poultry workers as well. But how to go about doing it? Well, within a very short time, after making the announcement that there would be visas for such foreign workers, there was provision for a concession anyway outside the rules to allow such workers to come in. Guidance was issued to Home Office caseworkers, but within a very short time, Appendix seasonal worker was itself amended by new immigration rules. Now, this is Command Paper 542, Command Paper 542, issued last Monday, the 11th of October. Let me just read you a few bits from the guidance issued by the Home Office to sponsors. So it's entitled Sponsoring Seasonal Workers. And the overview says, to sponsor a worker on this scheme, you must be an approved scheme operator who administers the scheme and acts as the licensed sponsor for the workers. So you've got the edible horticultural sector, quota of 30,000 per year. You've now got temporary visas for 5,500 poultry workers. All visa applications for poultry workers must be submitted by the 15th of November. No further certificates of sponsorship must be assigned after that date. There will also be temporary visas for 4,700 haulage drivers involving transportation of food goods and split between the scheme operators. All visa applications for haulage workers must be submitted by the 1st of December. Now, how long can these temporary workers stay? The poultry workers have got until the end of December. So once the Christmas period is over, that's it, home they go. The haulage drivers can stay until the end of February. Now, in fact, 5,000 haulage workers are going to be recruited, the government hopes. 300 places have been set aside for EEA nationals who don't need visas to come here at all. They must have an EU HGV or equivalent driver's license, so they're able to drive heavy goods vehicles in the UK, and they are only able to come themselves to apply for the route up to, I think the time has already elapsed. They only had a fortnight window between the 2nd and the 15th of October to apply. And then if they did apply, they would be able to stay until the 31st of March, a month later than the other haulage drivers. Well, apparently the take-up has been very low. Instead of 300 haulage drivers, well, a bit like the 300 Spartans, 300 drivers, they haven't got 300 drivers, they've got more like 30. The trouble with these short-term visa schemes is that they have to be attractive enough to get the foreign workers to come. And for those who need to have a visa and a sponsor license and so on, it's quite a bureaucratic hassle. If there's plenty of work for them in Europe, where they don't need a visa, they can travel among the member states, no problem. They're not going to bother coming here. And the outlook, I think, is not too good. It's not helped by the fact that the government itself is very, very reluctant to allow foreign workers to come in at all, unless they are highly skilled and can come within the skilled worker route. Now, things like driving heavy goods vehicles are reckoned to be unskilled. Ooh, I'm not so sure. It's hard work, and it surely does take some skill to manipulate a very large, heavy lorry. So maybe we need to buck up our ideas about this distinction between skilled and unskilled work. But we see this same attitude when in demanding that Indian youths who want to come under the Youth Mobility Scheme have to have achieved qualifications at degree level or be professionally qualified at that level. Why? Because youngsters from other countries can just work in bars and restaurants if they want to. They don't need any qualifications at all. So I think this is going to, this attitude is going to cause problems in recruiting enough workers to do the jobs which really are essential for food and petrol and other essentials to be made available to the public. I'll just leave you with something which I overheard the other morning on the Farming Today program. It's at 5:45 on Radio 4. I'm sure you're all up having breakfast by that time, so you ought to tune in. It's very interesting. And time and again, I've heard this on Farming Today, and the other day was no exception. farmers complaining to the interviewer who says, look, the government says, why can't you give jobs to local people? Why can't you train local people to do it? The government doesn't want you to rely on foreign workers. They want you to have local people working for you. And the farmers were saying, look, we've tried it. We've tried it before. Every time we get local people to come and pick the fruit or the veg, they don't come back the next day. The work is too hard. We rely on Eastern Europeans. So what's to be done? The British people just don't want to do hard work, so it seems. Anyway, folk, I hope it hasn't been hard work for you listening to me rabbiting on. And I'm not going to talk about asylum. It's really just about the two schemes which are up and running now for Afghans. And you can read about those at your leisure. Now, I see that Samina has come in. I've overrun by, I think, a good 2 minutes. So I better let you get started, Samina. Thank you very much. And I hope I didn't take you by surprise with my query about the joining family members wanting to join people with pre-settled status.
Richard, thank you so much. As always, it's a pleasure listening to you, and we don't mind if you overrun at all.
Thank you.
But no, you didn't take me by surprise, and that's why we have particularly today, or I'm going to particularly today, be covering over the EU settlement scheme. When I first started to prepare the talk, essentially, it was because we wanted to see what was going on once we've left the EU, how EU nationals were coping and what kind of applications they were making. But I think I've come to the conclusion that there's even more confusion than there originally was, with lots of changes and lots of things still remaining. So lots of applications still outstanding. And Richard, you've pointed out something which I wanted to highlight actually today. So I will take us through it. I'm going to share my slides actually, which will be helpful. Let's see. And then I thought they were up. Sorry, bear with me a second. My slides seem to have disappeared. Yeah, they shut down. So that means I am now reopening them. And I will be with you in a second. Try that again. There we go. And just try to play those. Slideshow. There we go. I don't know if anyone can see those. Yes. Okay. Can someone just in the chat box just say if they can see these, and then hopefully we're good to go.
Yes, I can see them all right, Samina.
Ah, brilliant. Okay, just took a bit of time before they came up on my screen. Okay, so that's why coming back to the talk today, I want to recap on the EU settlement scheme and making late applications. We all knew that there was a deadline on the 30th of June by which to make applications. I also want to look at Appendix EUFP because that's still open for applications. And then we're looking at the changes to Appendix EU and Appendix EU Family Permit that came into force on the 6th of October 21. And then also covering these possible applications under Article 8. These are the ones under Appendix FM for EU nationals, and that's what Richard touched upon earlier. And I'm going to look at practical tips as well on possible challenges, also looking at what's been happening, what kind of challenges have been taken so far, and giving you practical examples. So hopefully you can see where you might be able to take a client's case a little bit further if you need be. And then ending with skilled worker. This is something I've covered with AstenJ before, but I think it's important to recap on it, simply because there are EU nationals who for the first time want to enter the United Kingdom as workers. So what are their options and what might you be advising them? So coming back to late applications under the EUSS, you'll see here that there are a number of links essentially, and you are going to be able to access the hyperlink there, or any of the source materials, by just clicking on those links. They're all interactive there, so that will take you straight to the withdrawal agreement. But late applications under the EUSS, as I said, the deadline was the 30th of June 2021, but the Home Secretary confirmed that people can apply after this deadline, and the test, or what they must show, is reasonable grounds to apply. Now that's all contained within the withdrawal agreement itself, but it's not until very recently that the Secretary of State of the Home Office made provision for it, or made it obvious within their own guidance. And that guidance is here, page 31 onwards. I'm just going to try and see if I can use this as a highlighter. So that will make it a little bit easier. So reasonable grounds is the test, as I indicated. And this here is the guidance under which you would look to see whether or not your client who wants to make an application now has missed the deadline, has reasonable grounds. And as I indicated, it's now also progressed to be within the immigration rules, and you'd look at Annex 1. I have hyperlinked that in other slides, so you can look at those, just click on that to go straight to Annex 1 to look at that definition. Now, looking at the guidance, even though this guidance is helpful, there are a few aspects of it which are going to need a little bit of monitoring. And what you're looking at with reference to reasonable grounds, or those who might be included, who might have reasonable grounds to make an application late, are children, particularly those whose parent, guardian, or local authority fails to apply on their behalf. They don't have to provide a particular reason about why the responsible adult failed to apply to the scheme. Usually everything has to be reasoned and evidenced, because they don't want to, they want to allow as much flexibility as possible, especially in relation to safeguarding of the welfare of children. So in relation to children, if you find parents fail to make the application, if someone comes to you, you can make an application and cite reasonable grounds that the parent has simply overlooked this. Serious medical condition or significant medical treatment, you're going to have to provide some evidence of this. So that's going back to evidence-based, but that's simply to say that you had some sort of ongoing treatment, or your client had ongoing treatment, which is why they couldn't make this application. Victims of modern slavery, again, those are individuals who've had perhaps a reasonable, conclusive, or positive, reasonable, or conclusive grounds, and they can show that they've been a victim of modern slavery. So they're an EU national, and they can still make an application under the scheme. Abusing and controlling relationship or situation. Here within this, the guidance highlights that the Home Office should be flexible and pragmatic and accept other evidence. There's no specific evidence which is needed to demonstrate ill treatment, so be as pragmatic as they can. Those who lack physical or mental capacity, again, flexibility is required with reference to these individuals. And then you've got the much, much wider category here, other compelling or practical or compassionate reasons. And this essentially is those who simply say, and we know within the community, unfortunately, a lot of people were just not aware, once they'd settled their EU status and have permanent residence, perhaps they don't speak English, or they didn't have internet access, or they just simply didn't know, so lack of awareness, limited English essentially as well, then those are reasonable grounds as well. They can be put forward and they can make their applications late, essentially. But I think it's quite flexible, and it's there for us to utilize. So if we have a client who's come to you, even at this date, even 2 years down the line, because of whatever reason it might be, and haven't made an application but are still in the UK with old EU status, they can make this application. Now, I've just posed this question here, which I will try and answer a little bit later, but does this cover delays where durable partners were unable to marry? So COVID delays, a durable partner didn't have the EU residence card, a residence card under the EA regulations, so they don't have a relevant document, and they were unable to marry, but they can show they have proof that they were attempting, they'd been to the registry office, they just hadn't been able to get married before the deadline of 31st December 2020. I did have a case like that, and unfortunately this guidance doesn't cover that situation, and I will look at that in a little bit more detail under Article 8 and what kind of applications you might be able to make with reference to such individuals. So durable partners, keep that in mind. Okay, let me go to the next slide, and I want to flag this because these are individuals who are outside the United Kingdom and still entitled, they're not bound by the application for those, the date of the 30th of June 2021 by which applications must be made, and this is because they're outside the United Kingdom. So they apply under Appendix EU FP for a visa or a family permit under the EU settlement scheme to enter the United Kingdom. Look back at Appendix EU FP, so that's specific immigration rules for family permits outside the United Kingdom. And then this is specific guidance that we need to look at as well, which goes hand in hand. Again, that link, even the latest guidance is the 31st of December 2020. But if you go to that link at whatever stage, you certainly will be taken to that, you'll certainly be taken to that. I'm just checking because I've been told that I'm not on slideshow mode. So unless you can see my slides, I think I can continue. Let me just make.
Sorry, Samina, it was me bugging you. You're sharing your screen, but we've just got the title slide on, and then the slides are on the other slides are on the left hand side and they're not scrolling up, so I think there is an issue with the right. I hope it's not just me. That's better.
Has that helped in any way? I'm gonna
still very small.
It's just give me a second. I'm so sorry, everyone.
If you press escape, and then if you go to the slideshow tab at the top.
I think it was because it was
in presentation mode, I think, maybe, which then is not showing for us.
Yeah, no, I was using a second screen for some reason, which I usually disconnect from. So my second screen has, so I'm going to stop. And then I think my second screen obscured what I was trying to share. So there we go, slideshow and, oops. Okay, you can see it, but I can't seem to. We'll try and escape that again.
Sorry.
No, thank you. Thanks, Sarah. I was wondering why I could hear some buzzing, but thanks. Okay, so that brings me back to these slides here. And I'm really sorry for that. Hopefully you were following on the brochure slides that you've been provided by Wasantha in advance in any case. But here we go. Let's go back to this. So I was talking about this guidance here and Appendix EUFP as being relevant to look at when you make any applications from outside the UK. Now, it is a minefield, and you'll need to go into and consider these, not only the regulations, but also because you're looking at individuals who might also have outstanding applications and also family permits, or outstanding applications, sorry, which are then governed by these protection and temporary regulations. I'm just flagging them here because it's something to look at if you've got any outstanding applications, to ensure that you've got a continuing right to pursue the applications, essentially. Now, what I wanted to flag was the difference between these three categories. The EEA family permit is the one, and you'll see that as its name suggests, EEA was under the EEA regulations, or issued under the regulations. You have an EUSS family permit that simply acts as a visa and facilitates travel to the United Kingdom once you've obtained it. So it's what the family permit, it replaces essentially the family permit job. And the EUSS travel permit is if someone's lost their biometric residence card, it's been lost or stolen. When they're abroad, this is what they will be applying for from outside the United Kingdom to re-enter the United Kingdom. So that's just worth, I wanted to flag it, just worth keeping in mind, essentially. Now, which categories of individuals are going to be able to apply to this category? Well, the definitions are contained in Annex 1, but it mirrors Appendix EU categories, and it's for those joining or accompanying relevant EEA citizens who are resident in the UK prior to the 31st of December 2020. It's worth looking at who those relevant, who the relevant EEA citizen is. And certainly it's got to be someone who was resident here. And it usually only covers direct family members. So it won't be anyone extended family. It's closed essentially to extended family members outside the United Kingdom. And I also want to just flag the validity of an EUS family permit, because you may have individuals who've come to the UK either on this family permit, and they think that that's sufficient and that they don't need to do anything else. But unfortunately, it's got a validity only for a relevant period. So they're going to have to consider essentially that validity and do something further, which is essentially apply under the EU settlement scheme in country. And they're allowed to do that because they already hold a document under the settlement scheme. So the settlement scheme is still open for an upgrade of your status. All very confusing, as I say, but that's why I wanted to flag that whilst we all know in our heads there was a deadline date by the 30th of June, that's not necessarily the case for everyone. And we've got to just keep an eye on that in case we have clients who come to us in that kind of situation. So we're looking at 6 months from the date of decision, the relevant period, that's when the document, just like a visit visa, the expiry date of it. But for those entering on or after the 1st of April 2021, which will be the case now, then they have up to a period of, I'm just checking it, it's their intended date of arrival in the UK is more than 3 months from the date of decision. Then they have a period of 4 months from the date of arrival in the UK. And that's provided for in Article 18 of the withdrawal agreement. So it provides, again, flexibility, acknowledging exit and the deadlines and so on, but allows individuals to still have some validity to entry, or giving them time to come into the United Kingdom and to be able to apply for their upgrade status as it is. And that permit, that can be used as a visit visa to come in and out of the United Kingdom as many times as they want to. So that's essentially the applying from outside of the United Kingdom and the EUSS family permit and how it works. Now, there's been a little bit, these are changes from the 6th of October 2021. They're almost effective immediately because they've been brought in to effectively correct errors in drafting perhaps, or where there's been gaps and lacunae, to ensure that that's now covered. you have almost a back, sorry, I'm just checking. So a bit of backpedaling here in relation to the definition of a visitor. So there was an exclusion previously for those who were visitors to be able to apply in relation to the EU settlement scheme in the United Kingdom. But if they are, that's now been included or deleted from Annex 1. So if you are a visitor in the UK, and you entered before the 31st of December 2020, then you could have been in a position to apply, so you can still benefit from the reasonable explanation for a delay and make an application if you entered as a visitor. And an EU national, essentially. Now, we think that it's probably allowed for some of those COVID pandemic disruptions as well. And you had many individuals who perhaps left the United Kingdom or stuck abroad for quite a while. Their documents or whatever their status was may have lapsed in some way, and they've returned as a visitor. And so this allows flexibility for them to essentially revive their EU status. And then this one, which is really interesting, relevant documents. Everyone may now be aware, having come across this, that there was a class of individuals who had essentially extended family members who'd made their application before the deadline date. Their appeals were pending before the tribunal, the deadline date being the 31st of December 2020. They'd made an application as an extended family member in the United Kingdom. So they were durable partners, sisters, brothers, essentially, made the application to get an EEA regulation card, a residence card under the EEA regulations, which would then be a relevant document for them to be able to apply under the settlement scheme. Now, they had appeals pending. But when their appeals were then allowed later by the tribunal post-December 2020, they found that the Secretary of State was refusing to issue them with an EA residence card. And that's because post-December 2020, there were no longer regulations under which they could issue a family permit. So I'm going to jump from that to this number 3 here, paragraph 3 here. And this led to litigation, which again led to a bit of backpedaling by the Home Office in this letter here, hyperlinked, from the Home Office to the organisation 3 Million. We've mentioned that before many times. It's a campaign organisation for EU nationals, and they've done a lot of good work, essentially, in identifying gaps and taking up the cause for those individuals who are stuck without status for whatever reason, but identifying gaps within the settlement scheme itself. And this letter from the Home Office highlighted that they released a concession, essentially, that anyone whose appeal essentially was going to be allowed, they would be issued with a letter. They would be granted a family, sorry, let me rewind on that. So basically, they would be, the concession outside the Appendix EU FP set out that the published EUSS family permit guidance pending further immigration changes would allow an EUSS family permit to be granted to an extended family member who applied for an EA family permit by the 31st of December 2020. So they set out this concession, it's within the public domain, and that essentially led to another change here within Annex 1, the inclusion of a family. So the relevant document will be a family permit or a letter from the Secretary of State issued after the 30th of June that you qualified for one. So it doesn't have to be the physical relevant document, the traditional relevant document, which was the residence card, but it can be a letter from the Secretary of State which acknowledges that an individual had this particular status or entitled to this particular status, and that's as a result of an allowed appeal in the immigration tribunals. So I'm hoping the connections or connect the dots here, and that all makes sense, but it's worth looking at those two documents, essentially, Annex 1, but also the letter there. There's just one last thing that I wanted to highlight in relation to kind of troubled areas where we might see some more changes, is how universities are treating students, EU students, essentially, because they're confused about which guidance they ought to be applying, and this is affecting their obligations regarding admissions and financial support for EU citizens. So this has been flagged by the International Monitoring Association, and I've added this link here just for the purposes of information. If you do have clients who are coming to you as students and they want a bit more information, that's where you can go to kind of as a starting point, essentially, before giving any advice. Right, so, and this is the issue that Richard had flagged up earlier in relation to those with pre-settled status and applying under Appendix FM. Well, why this change was brought about on the 31st of December 2020 to GEN 1.3D. It included the definition of someone who holds leave under the settlement scheme. So someone with pre-settled status, someone who has settled status, they're fine, they're regarded as a settled person. But those individuals who had limited leave, that is pre-settled status, and they're EU nationals, are they going to be allowed to apply for their family to join them after the 31st of December 2020? So as I've already flagged to you, you can make the applications under under the pre-settled, so Appendix EUFP for direct family members. But essentially, what if you were married after the 31st of December 2020? So this is where things start to get slightly complicated, because that's a post-exit, essentially, post-deadline date relationship. You then have to look for another way in order to make that application. And there wasn't another way to make that application until this was brought about within the Appendix FM. The definition was included within Appendix FM. So they would have to now, it's post 31st December 2020 marriage or relationship, and they want to bring their spouse in the United Kingdom. They're just going to have to do it in an ordinary manner as other third country nationals would apply as a spouse under Appendix FM. So that's where this is just to cover another lacuna that was identified again within the EU settlement scheme. So we can see that the EU settlement scheme is limited. And so what next? How do we handle where there might be a cutoff point, and how do we move on from there for individuals whose relationships are still continuing, essentially? So this is one way of, one of the changes that came about to fill in that gap, and it applies to all family visa categories covered by Appendix FM, so the same kinds of applications that you would make under Appendix FM, but also Turkish workers and business people. I've just flagged that for the sake of completeness. Now, this is something that Sarah had quite recently in one of her cases. So it's been flagged by her, and I think it's important that we all kind of just keep it in the back of our minds, exclusions. So this is talking about, if you look at those who are included within a possibility of making applications, it's those EEA nationals, I'm just reading it, in the UK who hold valid leave to remain or enter, and that's called pre-settled status. But what about where a family member who's a third country national who has been granted pre-settled status? Well, unfortunately, at the moment, they are excluded from, let's say it's someone who was an extended family member, a niece or nephew, and now they go on and marry. Well, they're excluded at the moment from being able to bring their from bringing their spouse into the United Kingdom under Appendix FM. Don't ask me what the answer is yet. It's yet to be seen whether this is taken up further. I think there are talks about it being explored further in relation to this particular lacunae. So watch out for that. And I've just flagged for you requirements for spouse under Appendix FM. Everyone is going to be more than familiar with that, but it's just for purposes of information there for you. The other issue that I want to highlight is something where in relation, so I'm talking about lacunae and applications that we're making or may have made in time, but still problems are occurring. This is a case in which our very experienced colleague Charlotte Beatty, many of you may know her already, but I flagged her name there because this is her case, and this is now a case in which she's been granted permission because she had a client who was a Bangladeshi national, and the applicant, they had the facts are set out here essentially, but the claimant was issued with a residence card under the EA regulations 2016 when she was under 21 years of age, so she never had to show dependency. It's as straightforward as that. But when she went to convert that into, or upgrade it, or whatever you want to call it, as status under the EU settlement scheme, she'd now become over the age of 21. But her application was refused because they said she would have to show dependency. But how can that be? I mean, she still fell. She was simply converting essentially her old status into what the government was saying has to be under the EU settlement scheme in order to continue to leave. So an application was made there to challenge essentially the provisions of Appendix EU as not being compatible with the withdrawal agreement. Essentially permission has been granted. It's been seen as a very complicated case, novel issues, and definitely with public interest considerations. But if you want to read more about that, I've highlighted a link here which goes to our Twitter account, Chamber's Twitter account essentially, and you can read a little bit more about that case. So like I say, it's not an easy answer. There are other examples of potential issues. This is, I've touched upon it before, extended family members who in this case, this was a sponsor who was a third country national who was granted residence card as a durable partner, and she basically had a child outside of the United Kingdom, but she did not apply, unfortunately, before the 31st of December 2020 for a relevant document for her child's relevant document. The child's now over 21, so the question was what to do. Basically, all the other family members had made it into the United Kingdom, essentially. So essentially, the first thing she did do was make an application under Article 8. But having considered the factual nexus of her particular case, there was nothing to stop them also making an application under Appendix EU FP and asking them to consider, even though she's an extended family member, to consider the entirety of the circumstances. So that's an application that's still outstanding, and it's a wait and watch, but representations have to be made as fully as possible to ensure that you're highlighting the essential components of your case, the factual nexus of your case, and whether or not then they are on a discretionary basis, or the flexible nature of Appendix EU FP or the EU settlement scheme itself are going to be granted, is a wait and watch essentially. But protect your position with an Article 8 claim, and then also see whether or not it's potentially your client can fall to be considered under Appendix EU FP or the settlement scheme. And then I touched upon durable partners getting married after the 31st of December 2020. This is someone who hasn't held an application, a residence card prior to 31st December 2020. They just didn't make it, but they were, because they thought, well, we're going to get married, but then COVID pushed out their marriage post December 2020. And that was all caused by COVID delays, and they have evidence of it. So this is again another case that I've seen which they had evidence all the way through that this particular claim that they were going to get married a year in advance of COVID, and through COVID, the delays that led to a year in advance of the December 2020 date, but that led to a number of delays. So what do they do? Again, essentially an Article 8 claim under Appendix FM, but I think in this particular case, again, it's one where COVID delays, if you're looking at the withdrawal agreement and that's providing for reasonable delays, no one had envisaged COVID or that there's going to be delays as you know, which causes an individual to not be able to satisfy another important component, which is to demonstrate that they're married before making an application. I think there is this possibility of us making an application again under the settlement scheme here and putting in all the evidence to show the COVID delays and that they were supposed to be married prior to the deadline date. Again, that's another wait and watch situation to see what does happen, whether that's granted. If not, and if those applications, let's say, have been made and you come to the Article 8 claim, because they may well have Article 8 claims pending, then you're going to be able to put forward all the arguments that you would have put forward in relation to these cases, including compatibility with the withdrawal agreement to identify what you think might be a lacuna, essentially, with reference to the issue of proportionality. Now, you'll need to carefully craft it. I think those many members in our team are using this as a solution or a way forward, but you'd have to carefully craft the arguments in relation to Article 8 claims. I've flagged here this case, which I think many of you are going to be very familiar with in any case. It's the case of Ami Temor. It was heard first in the upper tribunal, and it made its way up to the Court of Appeal. And both essentially found that if an appeal is brought in the first tier against an EA decision, then only relevant issues that can be raised during that appeal are connected to the EA decision. Human rights issues cannot be or are not permissible, essentially. So whilst I looked at the opposite way in the previous slide, which was make the Article 8 claim and then argue the EUSS arguments, that you can't do it the other way. But I think the tide might be turning. It's again a wait and watch. In this situation, if you had a one-stop notice, then if that was issued or there were removal decisions, you could have argued Article 8 in an EU application. But the other thing to watch out for in any refusal under the settlement scheme is that if the Home Office do end up mentioning in their decision that considering Article 8 arguments, then it may well be what's been said here was that they've exercised their residual discretion with reference to Article 8 and waived essentially the need for a separate paid application. So it's just something to flag here to watch out for if in a settlement scheme refusal, you find that they've mentioned Article 8, whether or not you can go on to then argue Article 8. As I say, I think that the tide's turning because you've got cases like Akin Sanya, which where the right of Zambrano carers was previously restricted, and the Supreme Court has extended the scope for Zambrano carers applications and so on. So it's worth keeping an eye on this and keeping an eye on the kind of arguments that you can make within a settlement scheme refusal to the tribunal. And that moves me through to the last part of my talk, which is skilled workers. And I think I'm quite creeping up to the deadline anyway, just having a look at the time there. So this is skilled workers, and the reason why this follows on for me from all the EU and EA aspects that I've been talking about and the applications you can make and the issues that have arisen, is because the next step for someone who's coming to the UK for the first time, who is an EU national, who wants to come here and work, and whose company's offering them employment here, anything like that, they would be making an application. It's not all ended for them. They will be making an application for as a skilled worker. And so I wanted to flag this. As I've said, I've already done skilled workers as quite a detailed topic. This is simply a reminder for us that it doesn't all end with the settlement scheme and the EA regulations 2016. Life goes on, and individuals can continue to come from the EU. And for this part, they seem to have simply, even though I'm going to take you through certain elements which seem quite complicated, it is essentially quite simple to be able to get through here. And they've made it as flexible as possible from what I've understand and the practical experience that I've had with this category. So for this part of the rules, individuals need to have 70 points in total, 50 points mandatory. So it starts with the mandatory elements, which are straightforward. You've got to show your sponsorship, job at an appropriate skill level, English language skill levels, and then you need to look at the other part of the application, which is this 20 points for tradable, they're called tradable points. And for this part, you have to look at the minimum salary threshold. And the general threshold here is 25,600, but the specific salary requirement for the occupation, or the specific salary requirement for the occupation known as the going rate. So that's all contained in the various appendices. I think Richard was mentioning different appendices for different things, but you've got the appendix skilled worker SW, excuse me, to look at in this particular case, but there will also be various other appendices when you're checking the occupations. I think there's an appendix SOC, if I'm not mistaken, but I've left a source page on at the end of this, and you can refer to the various appendices there. But this also, these tradable points, they're called tradable points because they also allow for applicants to trade characteristics such as qualifications. Perhaps they're new entrants to the work market or a certain age, to lower the salary threshold so that they can, the threshold does not have to be 25,600 anymore. It can be much lower than that. So that's worth keeping in mind for your clients who come to you to have a tick box exercise to see what qualifications or where they might be able to fit in relation to tradable points, or that 20 points, what they might be able to show. And just to keep in mind as well that this is a category that leads to settlements. So so that's it's a good category to be in. There are a number of other categories on the point-based system, but this one's quite an easy category to be in to lead to settlement. Essentially, I say easy, not as easy comparative to being an EEA resident, EU national with EEA residents rights in the United Kingdom. And of course, they ought to be, this visa application is being made to with reference with reference to a Home Office licensed sponsor, someone who already holds a sponsor license. That's, I mean, that's just something that often there are many companies now who are making those applications. So it's quite a good route for EU nationals to make those applications with reference to those kinds of companies. I've flagged here various categories and the eligibility in a little bit more detail. I just think it's worth looking at them really quickly because we are running out of time. But sponsorship points, you need to have a valid certificate of sponsorship. And there are two types, defined COS and undefined COS. They kind of replace the old restricted and unrestricted COS system. So it's worth looking at that. I've already touched on having a licensed sponsor. So that's quite straightforward. Immigration skills charge. This is a new charge. It's not the immigration health charge, but it's a skills charge which the employer is going to have to consider. They would have to pay. So that's quite straightforward. The more interesting aspect is this one here, genuine vacancy. They're going to have to demonstrate it's genuine vacancy. There's no longer the RMLT test, but I think it's almost like a backdoor to looking at genuine vacancy. And the test for whether or not something is a genuine vacancy, again, comes down to this definition of having reasonable grounds to demonstrate that it's not a genuine vacancy because the job doesn't exist, it's a sham, it's created especially for an individual to gain entry or leave in the UK. But they are going to be very flexible when they look at these categories. And I've used the word flexibility quite a few times because they will ask for further information. You're going to have to demonstrate at every stage. If they don't, they are quite pragmatic and flexible with this category of visas, but if they need further information, they will come back to you and you'll be asked to provide that information. So it's inbuilt flexibility within the rules. And then also you must be careful that if you're working for a third party or a contractor, you ensure that you are being sponsored by the correct person who's making payment for this individual, who's paying the wages and so on. So that's something that they will be looking out for. And then job at an appropriate skill kind of crosses over with the genuine vacancy. It's got to, and I said this before, it's got to be a role under the SOC, so look under Appendix Skilled Occupation Code. And again, the test is reasonable grounds. It's not an exaggerated or incorrect code. They'll be flexible in asking for further information in relation to this aspect as well. And that takes me to the last part, which is then the English language requirement. It's straightforward. They need to show B1 level in all 4 components. That's a whistle-stop tour of skilled worker visa. As I say, I've covered it previously in another webinar in much more detail. I'm sure that many of you would have attended that, so I don't want to take up more time with that. Excuse me. As I promised, there was a sources page here with further links, and they should take you to those relevant appendices. And that essentially brings me to the end of the section on what's been happening, or hopefully keeps you all fully informed about what's been happening with the settlement scheme and what EU nationals are able to kind of look towards in terms of their future. I've noted lots of questions. I don't know whether we have time for any questions or whether we're on a break at the moment. But we certainly are having something at the end. We're having a panel discussion at the after lunch. That's right, isn't it, Richard?
Yes, that's right. I think given the rather strict timetable we've got, if people could save their questions for the panel discussion, we will be having a good 20 minutes and maybe longer actually. It's meant to run from 10 to 3 to 10 past 3 this afternoon, but I'm sure we could go on for a bit longer. So, you know, various topics could be raised then. And I suppose, Samina, maybe you could answer some of the questions in the chat box anyway, if there isn't time to actually talk about them during the panel discussion.
Okay. So would you like me to look at them now? Do we have enough time, Richard? Sorry.
Well, well, strictly speaking, not really, you know, unless we are to drop well behind in our schedule. Because really we're supposed only to have till 11:45 for our break, but obviously
Okay.
we'll have to take longer than that. So I think
can look
if
at
we
these questions and
sorry,
come back during the panel time. Is that better? Then we come back.
I think so.
Yeah,
yes,
perfect.
and we can always run on a bit from the panel time if it's not long enough. I think after that rather short break, we ought to be getting on to the next talk, which will be by Sarah Pinder on nationality law, I should say, and one particular aspect of that, Sarah.
Thank you, Richard. Yes, too many aspects, I think, so I may regret it, but ancestry and good character. So let's see.
All right, thank you very much, Sarah. I'd better get off the screen and let you have it to yourself.
Thank you, Richard. I'm just going to share my screen. Hopefully that's working. And sorry, I've got some noise outside, so hopefully it's not too loud for everyone. But good morning, everyone. Thank you for having me again. As I indicated with Richard, yeah, I may slightly regret what I tried to cram into this session. But hopefully you can bear with me, and I will very likely run through some of the slides without really speaking to them in much detail. But effectively we're going to look at ancestry and good character, and that sort of splits along the two halves of this talk. I'm going to cover an overview of how British citizenship can be acquired. That's sort of the basic criteria in terms of British nationality law, and the basic terms that you may already be familiar with, and so apologies if you are, but if not, some flags for you there. And then going into briefly ancestry and right of abode. I say briefly, now it's not really that possible to go into these things quite briefly because they are quite complex provisions, and there's been changes, and it's all you know, quite nitty-gritty stuff. But if you haven't delved into this before, hopefully they are flags really for you to sort of store somewhere, and then you can maybe go back to it in more detail if you have a case, or if you think someone meets the criteria. And then in the second half, we'll be whizzing through the naturalization provisions, but specifically in relation to the good character requirements, as I think it's worth running through those again, with you know, particular focuses on these things by the government in naturalization applications lately. So on this slide, I've just set out the overviews in terms of trying to trace a person's British nationality if you're concerned that they maybe are entitled to it, but haven't, you know, claimed that, haven't achieved that, or documented that. And then again, in cases, you know, where persons are looking to move to the UK and have that colonial or that sort of ancestry link, then it can be useful. So really look to identify the parents, the lineage, and you need to do so in nationality law terms. And really, I've just highlighted in the first few bullet points there, the position focusing on persons born overseas, because again, that tends to be the focus through our work in terms of who comes to make those inquiries, but also obviously it often presents the problem in the first place. So if a person is born overseas, they would only be British by birth if born to a parent who is British otherwise than by descent. And sorry, there's a typo, so that should be than by descent. Descent meaning here in terms of descendants, so descending from your parents rather than a dissenting judgment or a dissenting opinion. So the parent born in the UK, the parent that's British otherwise than by descent basically needs to either be born in the UK themselves or has been registered as British or naturalized as a British citizen in the UK. So if that is done in terms of the parent, so either born in the UK or naturalized, registered in the UK as British, they will be British otherwise than by descent. And if they then move and have a child overseas, then that child can become British through their parent, okay? But if the parent is born also themselves by descent, so you have several generations, if you like, of persons born overseas and becoming British only by descent, only through their parents having been born in the UK, naturalized, etc., then it's unlikely that that parent who's British by descent can also pass down their citizenship to a child who is born overseas as well, okay? But there are provisions that were previously discriminatory and that have been since rectified. So I just wanted to flag those two routes in effect in this slide and in the next slide, because they have given rise to persons being able to become British who otherwise weren't recognized as such. So the first group of cases here, as you can see, let me get my yellow, let's go magenta. Inspired by Samina's colour earlier. So single descent cases. So they are known as UKM applications. So UKM is the name of the form that is used, may have changed now with it being online, but certainly was the form that was used by the Home Office to register. So until 1983, 1983 is the key date because it's when the British Nationality Act 1981 came into force. And so until 1983, British nationality was discriminatory in the sense that it was discriminatory against women because the citizenship could only get passed down to the next generation if that generation was born abroad through the father. Okay, so a British mother, so let's say I'm born in London, I then go to South Africa and have a child there. Prior to 1983, my child would not be British, so I would not have been able, under the British Nationality Act 1981, prior to 1983, pass down my citizenship to my child born in South Africa. And it would only be if the father was also British born that the child may have a chance of being British through his or her father. Now, the British Nationality Act in 1981, when that came into force in 1983, corrected that, but only going forward. So there was no provision for retrospective births prior to 1983 being corrected alongside this provision. Okay, so coming into force of 1981 Act, you're okay going forward, but going back, there was still a problem. And that wasn't corrected until 2003. So it was effectively, I think, through the 2002 Act, if I remember correctly. So in 2003, the UK Parliament attempted to retrospectively tackle this historic gender discrimination. And that was by inserting a new section 4C into the 1981 Act that enabled applications for registrations as British citizens, okay? Partly because of the time that it took to correct that and for that to be brought into force, the applications for registration as a British citizen can be made for a child if obviously there's still some, but I don't think there would be now with the dates. But otherwise they can definitely be made as adults. So you could still be getting inquiries from adults born overseas and have a British mother, and they were not actually given a British passport earlier, or refused that, or didn't even think that that would be possible. And so there are cases still that can be corrected in that sense. So just be aware of that in terms of single descent cases. The second slide is even more complicated, so hopefully you can bear with me, but effectively we're looking at double descent cases. So single descent kind of blow my mind, double descent, well, I just don't have a mind anymore. But hopefully we can just go through this quite briefly, just again so that you're aware of it. And we're looking further back now, between 1949 and 1983. So again, 1983 being that key date because of the 1981 Act coming into force. And this is children born outside of the UK to British citizen fathers. But importantly, the whole issue and why we're talking double descent is because the father is also in this scenario born outside of the UK. Okay, so we have the father who's British by descent, and they are then having, that father is then having a child born outside of the UK. Okay, so we've got potentially two generations there born overseas. And the problem was that between 1949 and 1983, such kids born overseas wouldn't be automatically British by descent. So if nothing is done, they wouldn't be able to claim their British by descent status. And that is because their father also is British by descent. So it kind of had to stop somewhere, as according to the provisions then. But if they did do something, then they could be British by descent. And that something is that they could be registered at a British consulate within 1 year of the child's birth. So if the parent, the father, British by descent, took that procedure up, registered the child within 1 year of the birth, or later, subject to the Home Secretary's discretion, then that child would become British by descent. Okay, so second bullet point, this ensures that the child would be British upon registration. You have the provision there under the 1948 Act, and they would then be British by descent. And that's where it stopped there. So you had sort of possibilities of becoming British by descent twice, but the second time had to involve this registration application. And where we have the problem in all of this is that, again, this procedure was only available to fathers, okay, until we have Miss Romain, who's a British citizen by descent herself. She was born in South Africa, and she then had a child in the US with a US citizen. So there was no opportunity to claim the British by descent status of nationality through the father. And so she took this case on here in 2016, went right up to the Supreme Court, and the Supreme Court effectively opened up this route, opened up British citizenship by double descent to all children born between 1949 and 1983 to British women. So this, again, contrasting with the single descent, is to British women who are British by descent themselves, okay? The first correction was with regards to British born mothers, so British otherwise than by descent, okay? So that is a very good judgment, and again, opened up, you know, quite a category of persons there in terms of a long period of persons born overseas, but potentially have a British mother by descent and could claim that. The judgment itself is quite complex because it had to tackle with this procedure of the registration. And if it wasn't possible for women to pass down their citizenship, where does this procedure of registration come in? But in effect, you know, it dealt with it quite kind of pragmatically, and you have the citation there: the past is done and cannot be undone. The only way in which effect can be given to Section 4C3, which is this new section, is to treat the registration condition in Section 5.1b as being inapplicable in cases where citizenship citizenship is claimed by descent from a mother. And this is because the Secretary of State had, I think in this case, but also in other cases, argued, well, it's not enough to show that the provision is discriminatory against the women, because you also have to show that you would have registered your child within that 1 year, had you been able to. And again, you know, that's where the mind blows a bit. How can you show something if the provision wasn't available? How can you show that you would have done something if the provision wasn't available to you in the first place? So it was very circular. And again, I think the Supreme Court dealt with it well in being quite pragmatic and just saying, well, we've just got to correct this. And in that case, the registration condition, we just need to ignore it if you meet the other provisions in terms of timing of birth and ancestry. So again, you know, as I said, quite complex, but still kind of double descent, still remain in terms of the name in your mind somewhere or in your notes, and then you can come back to it if you think that you've got a case that may fall under this. And this is just a recap slide here. Born abroad between 1949 to 1983, either British mother or herself by descent, so that would be single descent cases, or double descent here, and then it's UKM provisions. There is some debate here because they're subject to the good character provisions. I think that's right. I would have checked it at the time. Some of the provisions where they rectify gender discriminations were not made subject to the good character provisions. And so, you know, I think that there is a debate there. Again, it's sort of trying to correct it as much as possible so that there isn't any kind of differential treatment. But do check that if ever. And then you've got the UK Home Office guidance there that is useful for you to delve in. And then the hyperlink there for you as well. So we leave that for now in terms of double descent and move on to the right of abode. Again, a bit of a minefield, and but can often, you know, it comes up a lot in terms of the inquiries where a person who hasn't got a British passport, hasn't achieved that, hasn't got that documented, makes inquiries as to whether they are entitled to it through their ancestry. So most of you will be aware in terms of the Commonwealth Immigrants Act in 1968, really kick-starting our whole immigration regime, really, and obviously nationality as well, dividing the UK and colony citizens into those with UK ancestry and those without. Okay, so for short, CUCs. Okay, CUC status. Those with UK ancestry sort of having perhaps arguably more preferential treatment, and those without less so. Those without the ancestry were no longer deemed to have the right to enter the UK. And then cementing that and sort of again building on it, we have the Immigration Act 1971, we'll all be familiar with that. And in particular, it's section 2 in terms of this concept of patriality. Okay, so this was a new kind of word, new concept that was introduced at the time. Patrials had the right of abode, but non-patrials didn't. So it kind of, you need to track it in the Immigration Act 1971, as well as potentially the nationality provisions. And here I've just summarized really who would be considered as patrials. The two most common ones that you would come across is first and the second. Again, you know, I can only run through this briefly now, and it does require careful analysis if you do need to advise on a case. CUCs who are born, registered, naturalized, or adopted in the UK and Ireland. So I have seen cases where, you know, a CUC is born in Jersey, for example. So it does come up. Or, so if they're not themselves as a CUC, born, registered, naturalization, adopted in the UK and Ireland, or they have a parent, but also a grandparent who was so. Okay, so you can trace it back 2 generations. CUCs who had at any time pre-1973 settled in the UK and Islands and then been ordinarily resident for at least 5 years up to 1973. Okay, so that can come up, Windrush cases, you know, those sorts of cases where, because of the hostile environment, it kind of brings that up. And you do, I have, not so much recently, but you do also have immigration cases where this comes up as well. The third, I will just speak to briefly, Commonwealth citizens. This can be useful if, upon the independence of a colony, they became a Commonwealth citizen, with that independent country being part of the Commonwealth. But it can be useful, particularly for the countries where, upon the independence of that country, a person born there loses their CUC status. So many countries were sort of that way. Regulated is not the right word, but you know, the constitution and all of the independence laws that came about at the same time were that way inclined in terms of losing the CUC status upon the independence of a country. They did still become a Commonwealth citizen. So if such a Commonwealth citizen has been born to or legally adopted by a parent who at the time of the child's birth was a CUC by birth in the UK. So that's where, in the case of Commonwealth citizens, we don't go back 2 generations, it's only the one. Okay, so that's the concept of the right of abode. Again, it does come up. The way it comes up for me, sort of still and most recently, is when persons have been given a certificate of the right of abode, whether they are living overseas and just come here every now and then, or are here. But when they come more recently to renew that, so to get a new certificate of the right of abode and a new passport, for example, then I think seeing the shifts in politics, seeing the shifts in how the Home Office operates, there's been doubts raised by the Home Office, and often, you know, not with any support or any basis. So you do, you know, cases that where it's all been tracked before, they do tend to sometimes come back up because the Home Office throws its weight around. The other context we've seen it again, perhaps less so with the right of abode, but more with the British nationality stuff, is again when persons, particularly Black and ethnic minority, etc., apply for a passport and have been asked to show how are they British. So that needs to be looked at very carefully, because it's again arguable whether they should have to do that or not, what's going on, why are they being asked this. But secondly, you know, there's ways of tracing this so that at least you can have some comfort as well. So that leaves the first part of our webinar, and we enter the second part in terms of naturalization and good character. The good character provisions, as I indicated earlier, do also apply to some registration routes. So not all, there are some that are exempt, and there's a slide for that later on. But they do, as I said, are mainly, in terms of our practice, they mainly come up in terms of naturalization applications. Initially only relevant to naturalization, but have been expanded, as I've just mentioned. I will not speak to this, but you have the tracks in terms of when it was sort of coming in as a requirement. However, what's important is that what does good character mean? How is that defined? What are the provisions that are looked at when a person is being assessed as to whether they've got a good character or not? Is not defined in statute. Okay, so that's what keeps us busy as lawyers. There isn't an easy regulation or set of statutory provisions to look at. It is all in guidance. Okay, and we'll come to that in a moment. It does apply to a person who is aged 10 or over, being 10 the age of criminal responsibility. So be careful about that. And then why Home Office guidance is important is because, you know, that is the guide to the decision making, the application of the guidance, and obviously what was taken into consideration in the decision making process. And so the guidance itself and reading the decision and how the decision-making process took place is therefore key, okay? And effectively, an applicant must be of good character, otherwise they risk discretion not being exercised in their favor, even if all other naturalization requirements and residential requirements are met. So as I mentioned, the categories here that are exempt from the good character requirement are set out here. So those that may be claiming through statelessness, those who have no other citizenship, section 4B, and section 4C, historic gender discrimination. So I think, and I do apologize, this slide was more recently prepared, so go by this one here, and I'll double check it just to be sure. But the Remain and single descent correction in the 1981 Act would not be subject. So if you apply for a registration under those provisions, would not be subject to good character, as confirmed here. And apologies that that earlier slide would have been wrong then. But I'm just flagging here the case of Howard. We don't need to go into it in much detail, but this was a High Court decision concerning a Windrush victim who applied for naturalization, if I remember correctly, and there was an issue of good character. He challenged it because when, if you remember, if you cast your minds back to when the Windrush scandal all sort of blew up in terms of its report in the media, and that led to Amber Rudd's resignation. Amber Rudd had, I think prior to her resignation, announced, it's basically to do with various policy announcements, and that policy announcement was that the naturalization fee, I think, would be waived for those that needed to become British, that were caught out by the Windrush issues. And I think various other policy announcements that I can't quite remember now. And then Sajid Javid became Home Secretary at that time. Obviously, we know it's been shifted more after that. But anyway, Sajid Javid came back on, or came on as Home Secretary. And it was under his tenure that this refusal of naturalization on good character grounds came about. And the Home Office was relying on a policy announcement of Sajid Javid to justify the decision, as opposed to Amber Rudd. And the High Court looked at all of this and basically said, no, it's not fair. You go back to those initial policy announcements as a result of the Windrush issues coming to light. So this case is good authority to support the fact that the good character don't apply to those that are, again, going through this process as a remedy because of the Windrush issues. Okay, so no need to delve into it much more, but it's there for you if you do. So the guidance coming to it is where you need to effectively become very familiar with it, but also go back to it if you're dealing with a refusal. This is a hyperlink, so go to the source if you need to. Factors to consider taken from the guidance: a person will not normally be considered to be of good character if there is information to suggest that any of the following apply: criminality, international crimes, terrorism and other non-conducive activity, financial soundness, deception, dishonesty, immigration related matters, deprivation. So a couple of things to say about this list. So firstly, highlighted will not normally, again, all the words implying a discretion, so not normally. So it's not a duty, it's not a must be refused, but it's a normally would be refused. Okay, so you've got to show why it shouldn't be refused if you think that that's the position. Second thing to say about the list is I've highlighted this one: criminality, international crimes, etc., and immigration related matters, only for my take. So that's what in my experience seems to come up the most. So criminality, we'll see why, but basically criminal convictions, fines, that kind of thing. International crimes, terrorism, and other conducive activity. At first blush, you may think, oh gosh, well, you know, what sort of clients does Sarah hang out with? But effectively, these tend to come up depending on the countries, but in asylum cases. And the guidance specifically says that even if a person is not excluded from refugee status, so hasn't been excluded under Article 1 of the Refugee Convention, that doesn't necessarily mean it doesn't carry forward in terms of any concern of the Home Office in a naturalization application. So depending on the countries, depending on the person's obviously profile, their activities and their positions back home, in inverted commas, you know, these things can come up in a naturalization application. Then I haven't highlighted financial soundness, but I wanted to highlight that they could be coming up more and more. So NHS debts, for example, it's only recently, really from 2015, that the NHS charging regulations for secondary care have come in. And so persons are finding themselves in terms of having, you know, an outstanding bill from the NHS. And that's crept in now in the guidance for naturalization. So that would be one thing to look out for. Deception and dishonesty, we know about that in the immigration context, and I will turn to it in a bit of detail. And then immigration related matters, so that's what comes up again the most now in relation to periods of overstaying, previous overstaying, in relation to perhaps illegal entries right at the start of a person's residence, that sort of thing. Deprivation, again, may be less common, okay? But importantly, the third thing to say about the list is that it's non-exhaustive, okay? It is quite a detailed, comprehensive list and set of guidance in the Home Office policy document, but nonetheless, it's covered here that it's non-exhaustive. So if there are situations that are not covered, doesn't necessarily mean it can't be the feature of a refusal. And again, the guidance also stipulates that if the person does not clearly fall into one of the categories outlined and there are doubts about their character, caseworkers may still refuse the application. Okay, so just ramming that even more clearly. And they are instructed that they may request an interview in order to make an overall assessment. So again, a discretion, so they don't have to, but we'll see a piece of case law that can be useful in this respect. What I've seen the most is not necessarily interviews, but a questionnaire. So if they're minded to take something into consideration that's not necessarily obvious, like a criminal conviction being received and so on, so perhaps concerns into the non-conducive activity or a background to the refugee application, to the asylum application, then you can receive. So the Home Office will set out a questionnaire, setting out questions for the client to answer. So it's more a sort of written exchange, but ultimately they can also request an interview as well. So criminality, I'm going to run through this because this possibly is what you have seen the most and need less guidance about, or need less refreshing. An applicant will normally be refused. So again, just stressing the words that imply discretion. Has a criminal conviction which falls within the sentence-based threshold. This is my paraphrasing, okay? So if you're not sure, go to the source itself, but effectively it's similar or analogous to the criminal deportation threshold. So by that, I mean, you've got a criminal conviction that's attracted a sentence of at least 12 months imprisonment, level 1, level 2 between 12 months and 4 years, and level 3, 4 years and above, okay? Or between 12 months and 4 years, but less than 4 years, I should say. And then stage 3, 4 years and above, okay? So similar, that carries through into naturalization as well. So at this point, if a person has permanent residence, has ILR, you know, that should be on your radar or on their radar as well. But that's fairly straightforward usually to work out. Persistent offender, again, the same sort of term. So we've definitely seen as the deportation regime, as the deportation rules have sort of been escalated or sort of firmed up, we've seen that then transpose into the naturalization guidance. So same term as in the rules, same sorts of guidance, or a person who has committed an offence which has caused serious harm. Okay, and then standalone in terms of sexual offences and being on the register. What I want to highlight in this slide particularly is that applicants are required to disclose all convictions regardless of whether they are deemed to be spent. Okay, and there's an exception to that if the applicant is resident in the Northern Ireland. Okay, so the provisions, I think, to the Rehabilitation of Offenders Act are different, and they don't need to disclose spent convictions. So that certainly, I haven't tracked it back, but that's certainly a change in my practice. So when back in the day, when I was a caseworker and sort of routinely going through naturalization applications with applicants, we would be working out when a particular conviction was spent, and we didn't need to declare that. But again, as we've seen these requirements to declare, conduct stuff in immigration applications, as we've seen that change and evolve and get more and more onerous, you have seen that again be mirrored in naturalization applications. So really from the time that in immigration applications you had to declare even things like cautions or things that were spent, then again that was transposed over. So that's one to watch out for, because again quite a lot of people will still ask you, well, do I have to declare? I think it might be spent, sort of thing, but some don't necessarily, and some will think that they don't need to. So that's just an area to be wary of, because here caseworkers, again this is taken from the guidance, caseworkers may, so again the discretion, may take into account any past conviction regardless of when they took place, as nationality decisions are exempt from section 4 of the 1974 Act, which relates to the Rehabilitation of Offenders Act. Okay, so again just becoming more and more onerous in terms of what how picky, how choosy Home Office caseworkers can be before there is a grant or a successful naturalization application. Pending prosecutions, not normally granted if they're pending. Okay, so that may cover a smaller amount of cases, but is important nonetheless. And then support for terrorism suspicion type cases. So you have refusals, again, not because you've been convicted of something, but perhaps views you've expressed, not us, but clients have expressed, and so forth. And so, be wary of those. Due diligence, get your instructions, do those checks before embarking on this. And here I've highlighted, you need to go to the link to get more details, but there was a recent case in September, SIAC case, so again indicating sort of how seriously this is taken and how the evidence is dealt with, but the appellant was successful in appealing effectively this refusal of naturalization on the basis of suspicions of the Home Office. Okay, rushing through a bit because I think I've got about 8 minutes left. Again, highlighting what comes up the most, but it's fairly self-explanatory here. Fines, again, must be declared. It's a criminal conviction if given to you by a court. So again, the sort of dummy questions are, was your fine a fixed penalty fine given on the spot by the police, or was it through a court proceedings? Must be declared, may result in a refusal if received within the last 3 years. Okay, so again, a shorter period here. From my memory of the Rehabilitation of Offenders Act, a fine, regardless of the amount, was spent after 5 years, but they're certainly looking at whether you've had a fine within the last 3 years, and I would be wary if it's again within the 5 years because of the Rehabilitation of Offenders Act, but you can look at it more closely. Fixed penalty notices, penalty charges notices, penalty notices for disorder, they're not part of your criminal record. Okay, so that's not officially criminal conviction. The guidance says that it's not normally resulting in a refusal unless you fail to pay or you had an appeal and it then resulted in a conviction because you weren't successful in appealing it. But again, there's further guidance to delve into. Particularly here, caseworkers are also instructed that multiple fixed penalty notices over a short period of time could demonstrate disregard for the law. So again, just quite wide discretion there that we just need to be wary of. The same with cautions and warnings and reprimands. At first you'd kind of think, well, shouldn't be a problem, but it could still be refused. Okay, and then other non-custodial out of court, that's another typo, sorry, disposal sentences, again, are dealt with in detail in the guidance. So the same, very much as I was saying earlier, the same deportation regime applies. So you have, the sentence-based thresholds if it's an imprisonment, but you then have out-of-court disposals and how those are dealt with, you need to look at those carefully still as well. If you have a caution or even a conviction, a fine, that sort of thing, and it's spent and you didn't think, therefore, the client didn't think, therefore, that they had to declare it, could come to bite you in of itself through a failure to disclose. Okay, caseworkers are instructed that where an applicant has attempted to conceal or has failed to take reasonable steps to notify the Home Office that they have a pending prosecution, the guidance on deception and dishonesty must be followed. So the guidance must be followed. That doesn't mean that the application must be refused, but again, implies steps to take in the decision-making process that you need to check. But just really for you to think about, in such cases, consider whether the person has deliberately sought to mislead, whether they have been dishonest in that failure to disclose, because it goes back to the immigration case law that we have in that context, a failure to disclose a material fact leading to automatic refusals under Part 9. And Part 9, as you heard Richard talk earlier, recently amended as well. If there was an innocent explanation, I thought it was spent, I thought I didn't need to declare it. But also other cases might be the timing of it. So at the time of your application, everything was fine, and then later, once your application is submitted, you're actually charged, the client is charged with something, you wouldn't necessarily have to bring that to notice of the Home Office. So there can be, debates as to whether a person deliberately sought to mislead or whether there is an innocent explanation. So you go back to that case law as well. But also see Balajagari, things that, aren't necessarily that obvious and are concerning to the Home Office and are leading them to be minded to refuse. Following Balajagari, whose case was, one of the appellants was represented by our colleague Alexis Slatter in Chambers. That case led to the minded to procedure. So if there is something of concern to the Home Office, but it's not necessarily something that's obvious or that would kind of strike out, they do need to inform the applicant of that in a minded to procedure. So coming back to that questionnaire or the interview that I mentioned earlier, they should be putting that to the applicant in some way. So that could be in a written form through the questionnaire, or could be in an interview, that kind of thing. So just be aware of that, and that's definitely something to pursue if there are concerns with such a refusal. If you just bear with. Sorry, it's very unladylike, but necessary. So just be aware of that. And we turn to the immigration related issues now, and I think I've got about 2 minutes to run through that. A lot of the guidance is stuff that we will be familiar with, so if you've got an extant deportation order, you've been accused or you've been charged, or there's some form of procedure taken against you as to having entered a sham marriage or facilitated such, failure to pay litigation costs. So that's what I was also referring to in terms of NHS debts. So that's creeping up a lot more. So we first saw it appear in Part 9 that an application for leave to remain or ILR would be refused. I think it's ILR would be refused if there's a litigation debt outstanding. And again, that's made its way into the naturalization guidance. Illegal working, absconding, you know, working in breach of conditions, claiming public funds in breach of conditions, all that sort of stuff can be immigration related issues that lead to the Home Office assessing you as not having a good character. What is kind of important to grasp though, if you haven't done so already, or what certainly posing lawyers and caseworkers and clients problems more recently, is the guidance that changed. I think it was in 2016, I think, but maybe a bit earlier than that, a bit more recently than that. An application will normally be refused if within the previous 10 years. Okay, so it's a long period of time that we're looking at these sorts of things when it's relating to immigration related issues. Okay, 10 years before the date of the decision. Okay, so again, question mark anything that happens between submitting the application and the decision, whether you're under a duty to inform, that sort of thing. But that will be also dependent on the form and when that was submitted, because I think the form will have evolved over the years and the declarations may have changed. But if the person has not complied with immigration requirements of the type that I've just covered in that period of 10 years, then there can be a problem, okay? And the application could be refused for that reason. And that includes, I'm just flagging here, not having comprehensive sickness insurance if you needed it at a time that is relevant for the naturalization application, okay? I'll come back to that shortly. But why I flagged this here is because we may be seeing that a lot more as a result of Brexit and persons going for British citizenship, who otherwise would not have and would have continued with their EEA citizenship as previously. So 10-year period, is that here to stay? Well, seemingly. So I'm just going to rush through this now and highlight the case of Al-Anin, or Al-Anin, I think it's Al-Anin, of 2019 Court of Appeal. So this person, this applicant, this appellant, tried to challenge the period of 10 years, that basically it was ultra virus, it was illegal for the Home Secretary to lay down a period of 10 years to look at the issue of good character in the context of immigration related issues, because the statutory minimum requirements in terms of naturalization applications relate to a 5-year period. So you have the 5-year period of residence, that you're here lawfully, you're 1 year without any conditions, so you've got 1 year of permanent residence in most cases, or 3 years if you're married to a British citizen is the residential period. So it was argued that that period of 10 years is obviously contradicted by that focus of 5 or 3 years. But the Court of Appeal said no, basically. There is no reason why the Secretary of State cannot impose an additional or extended requirement relating to breaches of immigration law as properly being a matter which is relevant to the more general question of good character. That requires an assessment or evaluation by the Secretary of State of all the relevant circumstances going to that issue. Okay, so it just shows how much of an issue there is in terms of this discretion area, how much of a prerogative there is given to the Home Secretary. And I can't see that changing. I don't know if this case has gone up to the Supreme Court, but I suspect not with the dates that we're dealing with. And even if it was, with the types of decisions that have come out of the Supreme Court more recently, I can't see that necessarily changing. So in my view, it's here to stay. There are exceptions for the overstaying issues, but I won't cover those in detail. Effectively, that they will not normally be a ground to refuse if you've overstayed for a short period of time. And that can be overlooked effectively because of the workings of the grace, what we call the grace period. If you submitted an application without leave within 14 days post 2016 of your leave expiring, whether that's Section 3C or actual leave, or 28 days if it's before 2016, that date in November 2016. That is really the only exception for periods of overstaying So you might be okay in terms of the 5-year period because you need to show that you've been here lawfully, but not necessarily prior to that. There may be longer periods of overstaying that were then corrected by a successful application. So just beware of that. And the same with illegal entry. So I can't speak to this because of running out of time, but that will cover a lot of persons who entered illegally, for example, in order to claim asylum. So the specific mention of that, we need to consider Article 31 of the Refugee Convention. That's expressly mentioned in the guidance. It would be inappropriate to refuse citizenship to people who entered illegally, claimed asylum and were subsequently granted status, blah, blah, blah. But those who need, it's expected that those who need international protection are expected to apply for it at the earliest opportunity and in the first safe country. So I'm highlighting this because it's obviously same sorts of stuff, to use a neutral word that is coming out in policy, in announcements, in the Nationality and Immigration Bill. And you can see the focus there. So there will be cases, the guidance says, where refugees will normally be refused citizenship because they entered illegally and chose not to claim asylum at the first available opportunity, or only claimed after enforcement action was taken against them. Okay, now there'll be plenty of cases where that happened. There will be plenty of cases where it's not a question of choosing, there'll be reasons, and there will be also reasons why the claim of asylum happened after this. Ultimately, the claim was successful, or leave was at least secured to lead to the naturalization application. But you can have this all reopened now through the guidance, and so we really need to be live to this. Comprehensive sickness insurance, I will leave, and maybe we'll touch on it in the Q&As. There has been a recent opinion in the Court of Justice of the EU, but it's an opinion only, so we're awaiting for the full judgment, and it's on CSI, and the nub of it is that you don't need CSI once you have achieved permanent residence in the EA law. So that will help some people, but not all still. And then refusals and remedies there. Effectively no appeal, recon requests, and then JRs. So you need to have your public law hat on and really have the guidance as your friend, because it all starts and really ends with that at the moment. So I hope that was useful. I'm sorry if I overran by my clock for 6 minutes. And there we are. So I hope that was useful for you. And I think I'm followed, if I look at my running order, by our friend Nishan Richard. There you go.
Sarah, thank you very much for your very clear exposition, as always. I think we can forgive you for overrunning by 6 minutes.
Thank you. You do every time, and I'm forever grateful.
It's not a felony or even a misdemeanor. So thank you very much. Well, I think Nishan has got a surprise for us. I don't actually know what the subject of his talk is going to be. So I'm sure it will be a treat, Nishan. So I'd better let you get started. And hopefully, well, I think our timetable is running over a bit. So we'll be having lunch a bit later than what it says on the timetable. Over to you then, Nishan.
Thank you. Thank you, everyone, for particularly indulging me. Haven't been particularly well, which is why the handouts have come in to Vasantha only a very short space of time ago. But my topics are, I hope, of interest to everyone. Settlement for refugees, and then talking about vulnerable witnesses within the Immigration Tribunal. Contextually, I'll talk about the background to both of those topics. Hopefully Vasantha has sent over the handouts to you all. They're not as glorious as Sarah's as ever, but hopefully they tell you everything that you need to know. So in essence, I'm talking about the scenario, the very well-known scenario of those who have limited leave to remain for 5 years as a refugee. As we know, many years ago, pre-2012, Those with refugee status would have leave almost on indefinite leave to remain basis. But the Home Office have changed that, and it's become topical and it's become slightly challenging. So normally after your 5 years are up, you pop along to your lawyers and they complete a set PR application for settlement after you've had 5 years limited leave to remain as a refugee. Those sort of applications don't incur a fee, as you all know, but often just require very limited information online now. It's filled online, as many applications are. But there's a bit of a trick with these applications. There's a tactical way of ensuring that you don't get knocked back. And before I get to the pragmatics of it, let me talk about the requirements. Now, the requirements to be met for indefinite leave to remain are that you have to submit a residence card for 5 years. In other words, your BRP card on a refugee basis. And then you'll have to demonstrate that you don't have a criminal history or evidence of extremist behavior that runs contrary to the British value, whatever that may be. And it's best to provide evidence regarding your country or origin, showing that there's been no changes of a significant nature, that you still fear persecution, and that your fear is well-founded. Now, the changes to the country situation must be such that the reasons for becoming a refugee have ceased to exist. The Home Office published country guidance. It's important that you look into it. And if you have, since the grant of refugee status, for example, established a private and family life in the UK, it's important that you raise that. I think I referred to the form as set PR. It's not, it's set P. And then you will have to give your fingerprints and your biometrics in the normal way. But one thing to point out, which is useful, as with set LR, the other form, if you've had 10 years lawful leave to remain, you don't actually have to undertake an English test or a life in the UK. I'd just like to talk to you about scenarios that I've come across, those that have been direct access and those that have come through instructing solicitors. Many of my solicitors, after they've completed the set P form, and when they've gone through completing it and uploaded information, have often received a letter from the Home Office stating that they are to provide a position as to why they should be entitled, as it were, to continuing refugee status. There's a way of effectively dealing with that situation, and prevention is better in this situation than the cure, for which there really isn't one. When you complete an application of this nature, always go back to the original judge's determination. And when you go back to the original judge's determination, look at the grounds on which asylum was granted. Look at what was in place by virtue of country guidance at the time. Look at what was in place. Look at what's in place now. Put together a witness statement. Attach evidence of any changes, not just in the case law, but in the profile of your client. Do detailed written submissions. Include the original determination and distinguish things if they are helpfully, going to provide you with a better response from the Home Office. But more so, and something that's useful, is don't forget that the change of circumstances doesn't have to be protection based. It can be family life, private life based. If you've established further ties to the UK, those are also things that the respondent, the Home Office, will look at. Medical issues. The set P doesn't go into much detail about positing those questions. It's deliberately quite narrow, I think, but the brevity of it doesn't mean that it's succinct. The brevity of it is often designed just so that you provide the basic information. So in my view, the more that you provide with that set P application, the more documents that you upload that are subjective is important. You can put in background evidence or objective evidence articles. We're not supposed to use the term objective, but we all do. You can put those in if they specifically demonstrate a risk. I mean, the Afghan cases spring to mind, the Sri Lankan cases spring to mind because of changes in Home Office country policy reports, UNHCR reports, Amnesty reports, and reports all round. So all of those matters, in my view, are relevant to the sort of information that you would need to produce. So my recommendation is, please think about the quality of what you produce and don't just put in a large appellant's bundle. If you do get a refusal, it's important that you look at whether it's worth going back to the caseworker to remedy any deficiencies that really have applied to that refusal. And don't forget, it will attract a right of appeal if you do. But if you followed my method of pretty much putting together more rather than less, but being selective in what you put in, it works well. Then we can look at what happens if we get to the next stage. Let's assume you have your indefinite leave to remain. People with refugee status can apply for naturalization in the UK once they've had ILR for a year. But as we all know, there have been cases in which previous refugees were not successful in obtaining citizenship because the government have tightened up the rules. And the trick is this, the rules are a bit tricky. Let's assume you were granted you're granted refugee leave to remain on the basis of your perceived or actual involvement with a prescribed organization. I won't go back into the good character requirement that was touched on earlier, but in simple terms, those are matters which are all relevant to whether you meet the good character requirement and what is encapsulated by the British value. So my view is definitely, again, provide your determination. If you're granted refugee status further to an interview, provide a copy of that interview. And it's my view that the better evidence you provide, the more chance that you have. I've got to tell you this, though. I have seen more and more refusals of nationality, more so than ever before. Sarah touched on it, and I'll just digress for a moment. Non-complying with reporting, working briefly when you thought you had valid 3C leave, but you didn't. So information, the quality of what you provide is really quite important. I'm going to go back to the background of why the Home Office now have suddenly become quite keen on reviewing everyone's refugee status after the 5 years have taken place. And it's because the Home Office decided that what appeared to be a policy of automatic settlement no longer exists. And the reason for that is that they believe that the assessment of protection is one that requires a continuing duty of review. The Home Office rationale is this, that if you're allowed to update your further submissions and your claim for asylum with the respondent similarly is entitled to keep reviewing whether you're entitled to that protection. And that safe returns policy, interestingly, can be activated at any time in the 5 years that you have your refugee leave to remain, particularly if criminality is involved or there is a complete change in the country's situation. Vice versa, I'm dealing with an appeal in the upper tribunal for an Afghan national. And it's on the basis that he has an internal flight alternative in Kabul, but not only that, that he can avail himself of sufficient protection from the Taliban. Now, I have drafted detailed written submissions to the Senior Presenting Officers Unit and to the Upper Tribunal to say that no matter what findings we make of the appellant's account of being of adverse interest to the Taliban in the past, the respondent's own recent country policy information makes it clear that there is no viable internal flight alternative. So on the grounds of humanitarian protection alone, he can't be removed. And I'm waiting. I mean, I'm not hearing anything from them. So I think the Home Office are adopting in Afghan cases a policy of wait and see. And then that conveniently goes into the rhetorical question, when is a refugee no longer a refugee? Now that's Article 1C of the 1951 Convention. It sets out a series of factors when the Refugee Convention recognizes that a status ends in respect of certain conditions. Now, in essence, legally, it means that once an individual is determined to be a refugee, their status is maintained until they fall within the terms of cessation clauses or their status is cancelled or revoked. Now, Article 1C of the 51 Convention sets out a series of circumstances. And I'll come to an interesting point that came up in a talk that I did not too long ago, in fact. And I'll just remind myself of that in a moment. But these are the circumstances that kick in when the Refugee Convention no longer applies. Where a person voluntarily re-availed themselves of protection of the country that they claim to be in fear of, having lost their nationality or voluntarily reacquiring it, the acquisition of a new nationality, or where the circumstances in connection with when and how they've been recognized as refugee have ceased to exist, and they continue to refuse to avail themselves of the protection of the country of nationality. And being a person who has no nationality, he is because the circumstances in connection with which he's been recognized as a refugee have ceased to exist and is able to return to the country of his former habitual residence. Now, one thing that the Home Office look very dismally at, that's a correct adjective, and they look down on, are those who, first of all, try and go back to the country of origin when they have refugee leave to remain. I mean, your travel document puts it in black and white that you simply cannot travel to the country from whom you've claimed persecution. I was told of a case very recently, which I find actually quite stunning. Pakistani national, by virtue of his sexual affiliation, was granted asylum. It was granted asylum, I'm sure, on the basis of that he couldn't, and this is what troubles me, that he couldn't practice or enjoy his orientation without there being consequences of repercussions by the state and non-state agents of persecution. But I'm told by the solicitor in question that he travelled 3 times from London Heathrow to Karachi during that 5-year period. He wasn't stopped on any of those occasions, on leaving nor re-entering. And yes, he flew on Pakistan International Airlines, so you couldn't be more obvious with that. When he applied for his Set P, he provided a detailed explanation that he was physically required to be there for the purposes of giving evidence in a criminal matter, and that he was able to successfully enter Karachi, live in an Airbnb apartment of sorts on those 3 occasions, and his lawyers provided detailed letters explaining effectively that he was required and an attorney couldn't act overseas without him physically being there. In short, he surprisingly was granted settlement. I think he was extremely fortunate, but I do have a number of clients who during the COVID pandemic have put this question to me, because the pandemic has affected us all. And that is that we're willing to risk it. My mother's going to die. I want to be there for her last rites. This covered Southeast Asia on quite a lot of occasions. My point to them is that if you go, you're probably not going to be able to come back in. Not only that, you've effectively unilaterally revoked and contributed to the revocation of your refugee status. So, I mean, it sounded obvious, but that example I thought was remarkable. Now, for the purposes of the safe returns policy, the provisions of Article 1C are important, and that is that the respondent can't just turn around and say, that there's been a peripheral or minor change in circumstances, they must be both significant and non-temporary in nature. But then it begs the question, where does the burden lie? Who needs to prove what? And Article 2, subparagraph 2 of the Qualification Directive tells us this, that without prejudice to the duty of the refugee to disclose all relevant facts and provide all relevant documentation at their disposal, the member state which has granted refugee status shall on an individual basis demonstrate that the person concerned has ceased or has never been a refugee in accordance with paragraph 1 of the article. So in other words, it's incumbent upon the Home Office when considering the application to prove that the change is significant. The asylum policy instruction for the revocation of refugee status states the following, that the overthrow of one political party in favor of another, even, might only be transitory, or the change in regime may not mean that an individual is no longer at risk of persecution. I dealt with a deportation case for a Sri Lankan national who had some years ago been found by a judge to be credible, and the judge also said it was reasonably likely that his details would be on the database at Bandaranaike International Airport. Unfortunately for me, he had committed a shocking criminal offence. I won't go into the details. It was a violent offence. It was gang related. But my previous finding of fact from that judge, that Dervasin fact, together with the view of the UNHCR. Now, the UNHCR often receive a referral and provide a view of some sorts. The respondent often has to comply with her protocol, which is to refer it to the UNHCR. My UNHCR comment wasn't particularly great, so I had to rely carefully upon the case of GJ Sri Lanka that was in place, talking of what is the stop and the watch list in Sri Lanka. And the stop list, in a nutshell, exists for those who have an extant arrest warrant or are known to the authorities, because their details would be on the computer when you arrive, that's accessed by the Immigration and Emigration Database, and you'd be arrested and detained on arrival. I succeeded on that protection point. Deportation was thwarted. So I was able to demonstrate that there hadn't really been a change in, if you like, in the way that you were looking at the facts of the appellant's case, but there'd been a significant change in the case law. And that's the Home Office point, was there was no significant change in case law that could alter any view from the UNHCR or themselves that the appellant really wasn't at risk. So that begs the question, significant and non-temporary changes. The states in question must assess the fundamental character of the changes in the country of origin, look at the general human rights situation, the particular cause of fear of persecution, in order to make sure in an objective and verifiable way that the rationale, the grounds on which the person was granted refugee status has ceased to exist. So you do need to look at holistically what's going on the ground in the country of origin. The Home Office need to look at the legislation, see what the Parliament in that country has been doing, see whether there have been any amnesties in relation to cases there, etc. Therefore, the country of origin must have changed in a profound and enduring manner. Things should have significantly have got so much better that there is no longer a worry, and the reasons requiring cessation must be compelling. I'm going to take a break of about 30 seconds there. Bear with me just to wet my throat, as it were, and I'll be with you all in a moment. An altogether different environment, the environment of a topical issue concerning mental health and appellants who have got physical and mental health issues. And it falls within the ambit of vulnerable witnesses. This has become quite a controversial and hot potato issue with the Home Office. And I'll get to that in a while. In many circumstances, and it's even more relevant now since COVID, we can make applications for appellants of witnesses to be treated as vulnerable. It's open to the tribunal then to make a finding that a witness is vulnerable of its own accord, in fact, even if an appellant's rep doesn't put that forward. And the tribunal can also put in place special measures, etc. What makes an appellant or a witness vulnerable in immigration appeals is really governed by the presidential guidance note, which actually is very, very useful. And it says that an individual may be vulnerable because of innate characteristics, age, personal characteristics such as mental health, or because of events over which they have had no control, past detention or torture. Now, as defined in the President's guidance, the tribunal should attribute the same meaning to vulnerable adult as they do in other circumstances. And this defines circumstances in which an individual will be viewed as vulnerable, including whether they're in residential accommodation, sheltered housing, detained in lawful custody, or those who require assistance in the conduct of their affairs. But the presidential guidance also indicates that whilst those listed above may be easily recognized as being vulnerable, there are cases which might be less clear and they require further scrutiny. The presidential guidance requires the following factors to be taken into account: not just mental health problems, social or learning difficulties, religious beliefs and practices, interestingly, sexual orientation, ethnic, social or cultural background, domestic and employment circumstances, or physical disability or impairment rather, that may affect the giving of evidence. As a few of the speakers here know and who are familiar with Birmingham, and it's not just Birmingham I'm talking about, so I'm not singling Birmingham out. About 2 weeks ago, I had a CVP hearing, entry clearance appeal, lady from the Ukraine. I think she was from the Ukraine. And I wrote to the tribunal and said that I consider myself to be vulnerable. I have young children, one of whom, her close friend, had contracted COVID, a mother with various medical issues, none serious, but serious enough to justify converting a hearing to CVP because it was the fuel crisis at the time. There's no way of driving from London to Birmingham, and I suggested that going on a packed train wouldn't be advisable to the court staff, etc. I get a forthright email back from the tribunal caseworker telling me that if I think I've got COVID, go and get a COVID test. I thought that was very, very responsible, and I emailed him back to say, could you put this before a judge? Because I'm not sure this is an appropriate way to respond in the present pandemic. I get a response back from a judge who I know quite well, who said to me that if I was concerned about traveling, tell the appellant to instruct alternative counsel. So I turn up to court and find out that the judge in question has been taken ill. The entire list has collapsed. And I go and speak with the sponsor, who's not only got advanced rheumatoid arthritis, osteoporosis, blood pressure problems, but was sitting down and was in excruciating pain. I speak to the staff to find out what's going on with the list. I'm told that I've been placed on the float list. I was told several hours in the day that I was being reallocated. I drafted a detailed letter, first of all, making it clear that had the TCW or the learned judge read the facts of this case, they would have realized that the sponsor was disabled and therefore vulnerable. Secondly, that it was unfortunate that the judge in question hadn't turned up. But then it even had further on from there, it became clear that the Home Office had prepped the entire entry clearance case on the basis of a previous refusal that had never been appealed. So if we're going to give some real credence to applying all of the issues around vulnerable witnesses, we need to read the papers first. And not only that, I'm just referring to the tribunal and the Home Office. So please make it abundantly clear that it's not just your witnesses sometimes who are vulnerable, the parties to the appeal, even those who are involved in them in a legal capacity, can also be considered to be vulnerable. And it's important often that CVP cases are dealt with in place of face-to-face cases But the Lord Chief Justice, I understand, has advised all judges that they are to appear in person. I understand from certain senior judges that their view is, well, if we have to get off our sofas and go into court, then so should all the witnesses, including those who are representing in a legal capacity. But that's not why the CVP cases came about. I think we still have a 31,000 case backlog. So if it suggests that your client's vulnerable, does that mean you just don't call them to give evidence? No, because it's open to the tribunal to put in place measures. And those measures really should be identified prior to the hearing. The judge can introduce the way in which questions should be asked. So, for example, to introduce the topic that needs to be asked, and the areas in which you're going to focus your questions on, because that assists the vulnerable witness to focus upon what they're going to be asked, and also gives them notice of what they're going to be asked so that they can prepare properly. But also that sufficient gaps are given for the witness to provide such evidence. Furthermore, some cultural allowances can be made. Adequate space for carers, comfort breaks, but I think it's also important that in line with the practice direction that both yourself and the Home Office sit down and agree a way forward in respect of the measures that can be produced. I dealt with a case last week where the consultant psychiatrist made it clear that the appellant engaging in an adversarial environment would result in a serious and irreversible decline in his mental health. The Home Office said, well, we have got so many measures that we can put in place to avoid that happening. It became a contentious issue, and the Home Office suggested that the appellant was trying to avoid giving evidence tactically. The quality of the psychiatric report has to really be put forward. That needs to cover why an appellant also cannot give evidence if certain procedural safeguards and measures are put in place. So do be careful. Don't just assume you can't just put an appellant forward as being vulnerable and they not give evidence. It's open to the respondent to make submissions of adverse credibility on that point. The next point, it's come up in the upper tribunal a few times over the years, is that if the judge fails to record in his determination that an appellant was not treated as a vulnerable witness and should have, what effect does that have on the outcome of the holistic credible assessment made by a judge? Well, if the tribunal fails to follow the guidance in identifying vulnerable witnesses and doesn't consider those measures, the case of SB Ghana made it clear that any credibility findings made against them could be inherently problematic to sustain, and therefore was open to challenge on appeal. And it was held in the case of SB Ghana that the purpose of the guidance was to ensure that the best practicable conditions are put in place for the person to give their evidence, and to ensure that their vulnerability is taken into account in assessing the credibility of that evidence. However, it's for the judicial fact finder to determine what the relationship is between the vulnerability and the evidence, and there needs to be a link between that. So the fact that a judge simply didn't treat somebody as being vulnerable doesn't mean that your shocking gaps and the discrepancies provided by your appellant can be withered away. So it's open to the tribunal to make such adverse credibility findings, despite having recognized an appellant's vulnerability and an individual's vulnerability. In essence, that's the scope of the vulnerable witness element of appeals. And I find it always useful not to have just a single psychiatric report. Have a witness statement detailing why the appellant's vulnerable. If you, as the advocate or your instructing solicitor, had difficulties taking evidence, put that in writing to explain why. But also, if you're going down that pathway, be careful, because you don't want to become a witness as well as an advocate in your own appeal. You can't be both. So if there's a caseworker involved, do have a statement from the caseworker. But also look at whether an appellant is fit to instruct you. That's important. And consider whether a litigation friend is required. Social workers often are involved with vulnerable witness cases. It'll be useful for you to ask for a special measure for your social worker, your client's social worker, to be in place at a hearing. That also strengthens the corroborative value of your claim that an appellant is vulnerable. Some judges give you a very wide interpretation of what is vulnerable. They believe that if a person has got quite average physical ailments, that it's not suitable for them to be in an adversarial environment, and will try and get, and as I've been directed to do in a case, to agree a set of facts and a set of issues with your opposite side. It's always useful to have that sort of, if you like, criminal hat on when you look at these cases, to see if there's a parameter in which that you can work within. The other issue is about CVP versus face-to-face hearings. I'll just come into that for a moment. My experience as an advocate, when I have vulnerable witnesses, is that it really, really alters dramatically. Some witnesses feel that they're in the comfort of their home, that they're able to get to water, and in particular, that they're able to feel at ease when giving evidence. Others feel that the judge and the Home Office haven't seen the white of their eyes, and therefore haven't been able to persuade the Home Office on the basis of their own demeanour. Others believe that really neither matters. In my view, I prefer the CVP hearings. I think it's important that appellants feel at ease either in the solicitor's office or chambers, or when giving evidence. I find that the Home Office cross-examine a little less. They seem to get less animated with CVPs. And they're also under a bit of pressure with regards to the time allocations, because CVPs are set down for specific times. I find that multiple witness cases, CVPs can be a bit tricky. But on the hand, I think CVPs have worked well, although my experience is they either work really well or they just go abysmally wrong, and there isn't a happy medium in the middle. I'm going to end there. I'm going to thank you all for letting me still come in, to thank Vasantha, to thank the speakers for assisting me. Again, a few medical issues means that I'm not quite on form as I would be, and I can't speak for as long as I would like to. But I hope that everyone finds those two topical areas as informative as can be, and probably revert across to Richard. Now it's 13:23. I think I've been going for circa 40 minutes or so.
Well, Nishan, thank you very much for coming and talking to us despite not being well. It's very good of you to have done that, and we really appreciate that. And we've also got your course notes. Vasantha has sent those out. Now, you may not be really up to being around later on for the panel discussion, which is due to take place round about 3 o'clock. Perhaps if there are any questions for you, you could just answer those via the chat box or the Q&A.
I'm going to try and be there for 3 o'clock. I'll try and use my best endeavours to be there. Well,
thank you very much. We shan't blame you if you can't make it, but hope to see you then.
Thank you.
Thank you very much, Nishan. And well, we now have a lunch break, and that is due. Actually, we're back on timetable, thanks to Nishan's talk being a bit shorter than the others. Welcome back, everybody. It's 2 o'clock and time to resume our webinar. And it's going to be me again, giving my regular update. So let me get started punctually, and I'll try and finish a bit early so we can have longer for our panel discussion, which is supposed to start at 10 to 3, but we may be able to start a bit earlier than that. Okay, so let me turn then to the first topic in my autumn update, and that is the well-trodden path of deportation. And in the last webinar that we had in July, I was talking about the Strasbourg jurisprudence, how that has loomed larger really in recent months, and in particular the case of Maslov and Austria, which is often prayed in aid when a deportee has been living in the UK since childhood, and that is said to make his ties to the United Kingdom a lot stronger and his connection with his country of nationality weaker. Now, the Court of Appeal and the Upper Tribunal have had quite a lot to say about Maslov and Austria, but this time we're going to look at a recent Supreme Court judgment, which is called Sanambar. And there was only one judgment, in fact, and it was written by the Lord Chief Justice of Northern Ireland, who was guesting, as it were, at the Supreme Court. The idea is that the heads of the judiciary in the different nations of the United Kingdom should all have a go at sitting at the Supreme Court. Anyway, if you look at the second paragraph of this section, it says that that Sir Declan Morgan, the Lord Chief Justice, reminds us that in Maslov and Austria, the Grand Chamber was considering the principles to be applied in deportation cases involving settled migrants who lawfully entered the host country as children and committed offenses as children. So there are 4 requirements, apparently, that the deportee should be settled, he should have come to the UK lawfully, he should have been a child when he arrived, and he committed his offenses as a child. Now that seems to narrow the scope of Maslov and Austria considerably, because most of the deportees who will be praying Maslov in aid will be adults, and they will have committed their offenses as adults. Does that mean that they're not eligible? I wonder if that is a bit misleading, because if we go on to see what Sir Declan actually said about the Strasbourg case law, he goes on to say that the Grand Chamber in Maslov were building on principles already established in earlier cases, Bultief in Switzerland, Hunair in the Netherlands, and there are 4 principles in particular that have to be taken into account in a deportation case. The nature and seriousness of the offence committed by the applicant, the length of his stay in the country from which he's going to be expelled, the time elapsed since the offence was committed, and his conduct during that period, and the solidity of his ties with the host country and with the country of destination, all obviously relevant, but not limited to somebody who committed offenses as a child. And in fact, you'll see at the bottom of the page, the court said it was necessary to take into account whether the offenses were committed as a juvenile or as an adult. And then it goes on in the next page. In short, the court considers that for a settled migrant who has lawfully spent all or the major part of his or her childhood and youth in the host country, very serious reasons are needed to justify expulsion. And this is all the more so where the person concerned committed the offences underlying the expulsion measure as a juvenile. So clearly that doesn't rule out people who committed offences as adults. It just makes it all the more difficult to expel them if all of this happened when they were still juveniles. So maybe Sir Declan is going a bit far in what he was saying earlier on, but he goes to one of our domestic cases on deportation, Pinder, from 2015 at the Court of Appeal. I must confess that was a new one on me, but it supports his view that Maslov did not lay down a rule of law, that there must be very serious reasons for expelling a juvenile, expelling a deportee if he came here as a juvenile, but rather it says that one has to sort of take an overall holistic approach, looking at all the evidence, conducting a balancing exercise, and not looking particularly at the fact that the deportee came here lawfully as a child and has spent most of his life here. So maybe we can't really lay too much stress upon Maslov. It's not a trump card that the appellant came here as a child. Now, for critics of the deportation system we have here, and in particular of those cases which are reported in the press, like when there's a charter flight going to Jamaica full of people who've served sentences in British jails, and many of them are prevented from leaving because of interventions by their lawyers. The tabloid press might say, you know, here we have rapists and muggers and drug dealers who are now going to walk free because of these dratted lawyers getting them off on human rights grounds. Well, anyway, the sort of from the point of view of immigration practitioners and those who represent deportees, the fact that somebody has lived most of his life here, and in fact, to use a phrase that was coined a few years ago, is a homegrown criminal, should really count against his being expelled to a country where he might never have been since early childhood. But I suppose one can't really rely on the fact that he came as a young child, because other factors such as the seriousness of the offending, the connections that he might still have with the country of his nationality, and what he's actually been doing in this country will all have to be taken into account in the overall balancing exercise. Now, what the Supreme Court were doing in Sanambar were dealing with an appeal from the upper tribunal, which had found that the appellant, although he had come to this country as a minor, that there were no very compelling reasons why he should not be expelled. He had been sentenced to 3 years at a young offender institution, and this, of course, brought him outside the scope of, well, not as bad as the offender who gets 4 years or more in custody, but bad enough to render him liable to deportation. Now, So Declan looked at the private life in particular of the appellant because he wasn't relying on family life. And although he didn't mention in terms the section of the 2002 Act, he did actually go through the 3 criteria of section 117C4, which is the private life criteria, which could form an exception whereby if all 3 boxes are ticked by the appellant, he can avoid deportation on private life grounds. But one of those 3 boxes was not ticked by the upper tribunal. In this case, it was the 3rd box, under which there have to be very significant obstacles to the appellant's integration into his own country. And the upper tribunal did not find that very significant obstacles were present, and so they dismissed the appeal, and the Supreme Court found that that was a conclusion which they were entitled to reach on the evidence before them. So that decision was not overturned. Now, just going to my comment about that, some of you may have read a piece in the Free Movement blog by Colin Yeo criticizing Sanambar for what it had to say about very significant obstacles and upholding the upper tribunal. And Colin complained that if you look at what those obstacles were, they surely are very significant. Well, just let's take a look at those bullet points. The appellant hadn't been to Iran since he was 9 years old. I suppose that's old enough to remember something of what it was like in Iran. So it's not as if he came as an infant and would have no memory whatever about Iran. The relative freedom enjoyed by young people in this country. Well, you could say he should have thought about that before abusing the freedom that he had here to rob people at knife point. He could not read or write Farsi, but he could speak it. Well, that would be something, because no doubt there are quite a lot of people in Iran who aren't terribly good at reading and writing. He was unaware of any relatives in Iran. This is always a problem, isn't it? When people are facing deportation or indeed removal, and they say, well, I've been away so long from my own country or the country of my nationality, I've lost touch with any friends that I had. I don't have any relatives there, or if I do have any, I'm not in touch with them, and they won't help me when I go back. Very difficult to prove a negative, isn't it? You say I've got no friends and I haven't been in touch with relatives, but you can't very well get them to write in and say, yes, I don't want to see him anymore. I've not been in touch with him. How do you prove this? And then the difficulties in obtaining employment. Again, this depends on the deportee saying, I can't actually rely on anybody to help me when I go back. And of course, in a third world country, a developing country, there isn't going to be a social security network to fall back on. You have to rely on family and friends to help you get a job and that sort of thing. Anyway, looking at those factors which the upper tribunal found not to present very significant obstacles to integration, let's take a look at another case which actually featured in the July webinar. And this is CI Nigeria. And here it was Lord Justice Leggett at the Court of Appeal who thought that there definitely would be very significant obstacles in a case where, and here I've quoted from his judgment, given the undisputed facts that CI has never set foot in Nigeria since he left when he was 15 months old, well, that is, of course, very much younger than 9 years old in Sanambar, knows no one in Nigeria, and would have no financial support from any family members or friends. Now, this would depend upon acceptance of his account that he doesn't know anybody and would have no support from any family or friends. And that the difficulty in obtaining accommodation, employment, and access to health services would be aggravated by his mental health problems. Well, of course, if a deportee also has mental or physical health problems, that strengthens the case against deportation. So there it is. Maslov isn't a trump card, but it's still of some use when a deportee has spent most of his life in the UK. Now I come to, well, the 7-year hitch. This hitch is a hitch to what was being argued in a recent case, NA Bangladesh, at the Court of Appeal, in which reliance was being placed upon the so-called 7-year rule. When children have lived in the United Kingdom for 7 years and their parents are facing removal as illegal entrants or overstayers, the fact that there is in both statute and indeed in the immigration rules provision for children who have lived here for 7 years not to be removed, this does strengthen their parents' case not to be removed either. Well, this is very well known. Now, in NA Bangladesh, we had a situation where 2 people from that country, a man and a woman, had come here as visitors or students and had overstayed. They had met and married, and they produced 2 children. So they had become overstayers. Of course, they were overstayers. But once the elder child had turned 7, and he was, of course, born in the UK, they made an application on human rights grounds under Appendix FM to stay in the UK. Now, under paragraph 276 ADE 4, you have the provision for a child like that who's lived here for 7 years to remain, provided that it would not be reasonable to expect that child to leave the UK. And then you've got in the 2002 Act, section 117B6, which says that a parent who has a genuine and subsisting parental relationship with a 7-year child, and it would not be reasonable to expect the child to leave the UK, that parent, it wouldn't be proportionate to remove that parent. So there you have the combination of 7-year child, not reasonable for the child to leave, therefore the parent can stay with the child. But does that mean that it's a trump card that the parent or parents, if they're both in that position, can now remain to bring up their child in the UK? Well, this case came before a bench of the Court of Appeal presided over by the Vice President of the Civil Division, Lord Justice Underhill, whose judgments in immigration cases, I think, are very highly regarded, very well written, and very hard to impeach on grounds of logic or reasoning. So, for example, there was the landmark decision in Hoke on long residence. That was him. And H.A. Iraq about deportation and the effect of children, which of course was very much welcomed by practitioners last year. Anyway, what does he have to say about the 7-year rule? He goes back to the case of EV Philippines in 2014 as the progenitor of what some people have been calling the powerful reasons doctrine. Now, Lord Justice Christopher Clark said that about the 7-year rule, first, because of its relevance to determining the nature and strength of the child's best interests, and second, because it establishes as a starting point that leave should be granted unless there are powerful reasons to the contrary. And something similar actually was said in an immigration directorate instruction that was current at that time, that strong reasons would be needed for a caseworker to find it reasonable to expect a 7-year child to leave the United Kingdom. So this was cited by Mrs., as she is now, Mrs. Alison Harvey, formerly the legal director of ILPA, as a reason why in this case, this Bangladeshi family, husband, wife, and 2 Bangladeshi children should not be removed to Bangladesh. And first of all, Lord Justice Underhill said, well, the best interests of the child are indeed a primary consideration, but they can be outweighed by the public interest. And he quoted what Lord Justice Elias had said in MA Pakistan, even where the child's best interests are to stay, it may still not be unreasonable to require the child to leave. Okay, and then he goes on to talk about the narrower approach and the wider approach, whether the parent's conduct is relevant to whether it's reasonable to expect the child to leave. And of course, that was settled by Lord Conworth in KO, Nigeria, when he said it's not to be taken into account. But that is qualified by the observation that it is generally in a child's best interests to remain with their parents. Unless special factors apply, it will generally be reasonable to expect a child to leave the UK with their parents, particularly if the parents have no right to remain in the UK. So that was this case. The 2 children had lived here now for 7 years, but the parents were overstayers. They had no right of their own to remain in the UK. And then Lord Justice Underhill reaches the conclusion, which is just before my comment. The upshot is that the effect of Lord Conworth's reasoning in KO Nigeria is that even on the narrower approach, in the case falling under the 7-year provision where neither parent has leave to remain, the starting point for a decision maker is the common sense proposition that it will be reasonable for the qualifying child to leave the UK with their parents. This is necessarily inconsistent with the so-called powerful reasons doctrine, apparently endorsed by Lord Justice Elias in MA Pakistan. Although Lord Conworth does not specifically spell that out, that is unsurprising, etc. So we can't rely on any strong or powerful reasons doctrine to say that a 7-year child cannot be removed, cannot be expected to leave, unless there are very strong or powerful reasons why it would be reasonable to do so. Now, of course, if both parents are without status in the UK and the children are not British, it's much harder now to argue that the family should be allowed to stay. Of course, if there is a British child involved, then the case for it not being reasonable for the child to leave the UK becomes stronger. And I give some other examples of where, even with a child who isn't British, it might be unreasonable to expect the child to leave, such as very long residence in the UK, much more than 7 years, hence the child being much more integrated and embedded into the society and culture of the UK. Another example would be if there's only one parent, let's say the mother, the father isn't around, she's been looking after a couple of kids who are not British. They too don't have immigration status, but they have been here for 7 years. If she's going to go back to her own country with the children, she could say, oh, it's going to be pretty hard for me to look after these children by myself. That there might be other reasons why she can't rely on family or friends in her own country. And so looking after young children, not having family support, if that's accepted, there would be a stronger reason why it's not in the children's best interests to go back to their own country just with her. And of course, if you manage to stay in the country with the children until they're 10 years old, then you have the right to register the children as British. And that again strengthens the case very much against the children being expected to leave the UK with you. Okay, well, I'm going to go on to something like a revision exercise on the basics of Article 8. So it'll be a bit like teaching one's grandmother to suck eggs. You'll know this stuff already, but I thought it would be useful just to run through what the court says here. It was a case of not a terribly elderly lady, 59 years old, who came from Pakistan on a visit visa. She had 3 grown-up children in this country, all pursuing professional careers. So everything seemed hunky-dory. But then it turned out she didn't want to go home. She wanted to stay with her children and her grandchildren in this country. And eventually she applied for leave to remain outside the immigration rules on human rights grounds. Now, there is a provision in Appendix FM for parents to join grown-up children in the UK, but they can no longer do it from within the UK. It used to be possible years ago to switch, to come as a visitor, and then switch to the dependent parent route, as it was then under Part 8 of the immigration rules, but no longer under Appendix FM. Of course, the fact that there is this route to apply for entry clearance as an adult dependent relative was relevant to whether she had a human rights claim to remain, although the fact that she chose not to use the adult dependent relative route was also something that detracted from the strength of her Article 8 claim, because she was presenting the Home Office with a fait accompli. She'd come to the UK, and now she's saying, look here, I'm a dependent parent of my grown-up children. Please don't send me back. So she got in here by circumventing the ADR route, if you like. So that rather counted against her. But on the other hand, was there family life between her and her grown-up children? It's well known, the leading case is Kugatis from 2003, that there has to be more than the normal emotional ties of affection between adult children and their parents in order for family life to subsist for the purposes of Article 8. But in this case, the court found that there was indeed that extra relationship of emotional dependence greater than the norm, which did indeed create family life for the purposes of Article 8. However, on the other hand, there was the fact that the family life had been created at a time when the immigration status of the mother was precarious. She was an overstayer. So the the leading judgment, it was Lady Justice Carr giving the leading judgment. She alludes to the case of Ali at the Supreme Court in 2016. And what was said then, that a central consideration when assessing the proportionality of removal is whether the family life was created at a time when the persons involved were aware that the immigration status of one of them was such that the persistence of that family life within the host state would from the outset be precarious. Well, that mouthful could only have come from a European court, and it was indeed based upon Strasbourg case law. Anyway, Ajarko as well in 2017 confirms that it will only be in exceptional circumstances that the removal of the non-national family member will constitute a violation of Article 8. When this is the case, family life created when the immigration status was precarious. And actually, this is where we get the business about exceptional circumstances and unjustifiably harsh consequences. We've got this at Gen 3.1 and Gen 3.2 of Appendix FM, where if the applicant can't succeed under any other section of Appendix FM, even EX.1, they can still pray in aid the provisions of Gen 3.1 and 2 that to remove them from the United Kingdom would result in unjustifiably harsh consequences, either to them or to, well, at Gen 3.1, it's the spouse or partner, and in Gen 3.2, to other members of the family. In fact, this provision, Gen 3.1 and 2, rather renders antiquated the idea that there's Article 8 within the rules. So, you know, the old two-stage approach to Article 8 appeals. First stage, you look at how the immigration rules, what provision they make for family life. And then if the appeal doesn't succeed at the first stage, you look at the second stage, Article 8, outside the rules. But really, now that we've got exceptional circumstances, unjustifiably harsh consequences, one could say that Article 8 is completely enclosed within the immigration rules, because you can always argue that a case is exceptional and therefore should be allowed under Article 8. That's in the immigration rules. Okay, so the stuff about creating family life, needing to be more than normal emotional ties with adults, the business about precarious immigration status, reducing the strength of the appellant's case, strengthening the public interest, that's all very familiar stuff. And really, in this case itself, the circumstances of the appellant were a million miles away from what would have to be established in an ordinary application for entry clearance as an adult dependent relative. There was nothing really wrong with her apart from a bit of osteoarthritis. That's a far cry from relying on family members for long-term personal care to perform everyday tasks. Okay, so really she was on a hiding to nothing in that appeal. Now, the next passage is on extended family members. And we've now had Samina masterfully dealing with European matters, and I don't need to detain you with this, I do give quite a bit of detail about how it came about that extended family members living abroad who had put in applications before the end of 2020 and who had either been granted their applications or more frequently had had to appeal against the refusal of EEA family permits, were stranded abroad because the Home Office was not issuing them with EEA family permits. And even the ones who had been issued with them found that they were no longer usable because they ceased to be valid after the end of June this year. And how, thanks to judicial review claims being made, the Home Office backed down. And just last month, at the end of last month, it was announced that extended family members who'd won their appeals and were now entitled to be issued with EEA family permits would be able to come to the UK anyway by tweaking EUSS family permits and getting them to be issued to extended family members, though in fact they're not eligible for them under Appendix EU family permit. But a concession outside the rules will enable them to be issued with such family permits. And then also when they come to the UK, although they would not otherwise be eligible to apply for pre-settled status, they will be able to, again as a concession outside the rules, until such time as the rules will be amended. Well, as we saw this morning with the seasonal workers scheme, it is possible for the rules to be amended at very short notice when it's a real crisis. But I guess getting petrol to garage forecourts and getting food to supermarket shelves is a bit more urgent than getting EFMs to join their family members here. So maybe it'll be some time before Appendix EU or Appendix EU FM actually get officially changed. Now, finally, I'm going to say a bit about long residence. One of my favorite topics, those of you who've been coming to previous AstenJ sessions will remember I've talked about HOKE and about how it's possible for people who've got gaps in the continuity of their 10-year residence in the UK, lawful residence that is, to succeed in getting indefinite leave to remain under the so-called 10-year rule, paragraph 276B. And there is a distinction which Lord Justice Underhill made between bookended and open-ended overstaying. Now, you are a bookended overstayer if you allowed your leave to remain to expire before you made another application for further leave to remain. Now, you've become an overstayer, but the Home Office will disregard the overstaying if a subsequent application for leave to remain is granted. Now, you haven't got forever to make a late application. It used to be 28 days after your leave had expired, or now 14 days. But anyway, if you do it within the grace period, it doesn't matter how long it takes for the Home Office to make a decision on your further application. If it's granted, the Home Office will disregard the intervening period. Now that's the bookended overstaying. You've got a chunk of leave on either side. What happens if you are heading towards the 10-year point, but your leave fizzles out before you've clocked up the full 10 years, and you then make an application for indefinite leave? Well, it could be that before a decision is made on your claim, you actually do you do reach the 10-year point, but your leave has expired in the meantime. what then? You're currently in the UK without leave, and you don't have a period on the other side with leave, as in bookended overstaying. You're simply an overstayer, and you actually can't then rely upon the 10-year rule. You're not eligible for indefinite leave. So this has been decided by the upper tribunal in Wasim, and pointing up the difference between bookended and open-ended overstaying. Now, there's another case, this time at the Court of Appeal, which is worth looking at. And this was a novel attempt by the Home Office to thwart a long residence claim. And I just need to go rapidly through the dates here. I hope it's not too confusing. A Mauritian visitor gets 6 months leave to enter as a visitor. So this is back in 2001. So he arrives on the 16th of April. He's got leave to enter until the 22nd of September of the same year, 2001. And before that leave expires, he goes back to Mauritius for the purpose of seeking a visa as a student. By that time, Mauritius was a visa national country, and so he needed a visa to come back as a student. I think Mauritius is now a non-visa national country again, but at that time it was visa national. So he did indeed get entry clearance as a student, and he came back after the 22nd of September when the previous leave expired, but with the entry clearance on the 5th of October 2001. Well, thereafter, he stayed on lawfully, extending his leave until July 2011. But then he overstayed for over 5 years until, having made a human rights claim, he got 2.5 years leave to remain. Well, that looks like the 10-year route, doesn't it? But he allowed that leave to lapse. It was due to lapse in 2.5 years, and he let it lapse. And instead, he made an application under the long residence rule because he had resided lawfully in the UK between the 16th of April 2001 and the 13th of July 2011, more than 10 years, save for the gap when he went back to Mauritius. Now, what about that gap? Doesn't it break the continuity of the leave? No, because if you look at paragraph 276A, which tells you about continuity of leave, this goes on to say about residence in the United Kingdom for an unbroken period as not having been broken where an applicant is absent from the UK for a period of 6 months or less at any one time, provided that the applicant has existing limited leave upon their departure and return. Well, this applicant had leave as a visitor when he departed from the UK, and he had leave to enter as a student when he came back within the 6 months period, well within 6 months. So surely he was covered by paragraph 276A, the fact that he was outside the country for several months, fewer than 6, doesn't break the continuity of his 10 years leave. Well, the Home Office prayed in aid another sub-paragraph of 276A, a sub-paragraph 3, where the continuity is broken if on departure, the applicant left the United Kingdom in circumstances in which he could have had no reasonable expectation at the time of leaving that he would lawfully be able to return. Now, the Home Office tried to argue that if you're here as a visitor, you have no reasonable expectation that you will lawfully be able to return. And this was pooh-poohed by the Court of Appeal. They said, well, in any event, this chap had had a multiple entry visit visa, so he could have come back anyway on that visit visa. But even if he hadn't, the proposition that a visitor can have no reasonable expectation of being able to return was simply wrong. And in fact, it was shown in the instant case that he was expecting to get a student visa to come back, and he did get it. So his expectation was reasonable. So that's quite a useful thing to remember if you ever have a client like that, whose continuity of residence was not officially broken, despite the fact that he might have been outside the UK for months, as long as it was less than 6 months. Bit odd, isn't it? You can be away from the UK for so many months. That doesn't break the continuity for the purposes of the 10-year rule. But just a pretty short break could stop you, because you're an open-ended overstayer. That could stop you from being eligible. There we are. Well, I'm just going to leave you with something completely unrelated to what I've been talking about, and it's not in my course notes, but some of you may have come across this problem. Recently, I was joining a remote hearing, CVP, and I was expecting just to see the sponsor, who was going to give evidence for, there were 4 appellants of family outside the UK, and they were all appealing against the refusal of an EEA family permit. There are an awful lot of these appeals still going through the system. So I wasn't expecting to see them, but lo and behold, there they all were, their faces on the screen. The solicitor hadn't told me this was going to happen. And anyway, when the judge came on, he was a very good judge, formerly a senior presenting officer at Field House, so he knows his stuff. And he mentioned the case of Nair. Well, I was expecting that because, as you probably know, video evidence from abroad can't be accepted unless consent is obtained from the authorities of the country where the witnesses are. And that provision dates back to 2011, and a case presided over by the vice president of the AIT, as it was, I think, at that time. Or was it the upper tribunal by then? 2011, I think it was the upper tribunal. It was Mr. Ogleton. And he said that you have to get the permission of the authorities from the country concerned before live evidence can be given at a hearing. So that rather hit the hearing on the head. The judge gave us time to get the necessary permission. It was going to be the embassy, or actually the High Commission of Pakistan. And what has to be done is that you have to, first of all, make a request to the Foreign, Commonwealth and Development Office, telling them why you need this evidence and who the parties are and further details. And then they will contact the embassy concerned to get the requisite consent. So the whole thing can take a long time, both getting the Foreign Office to assist, and then for the Foreign Embassy or the Commonwealth High Commission to give the necessary consent. The way to do it is to send an email to the Foreign Office, and if you don't already know, it's SOP inquiries@fcdo.gov.uk. SOP stands for Service of, oh blimey, not papers, process, yeah, Service of Process, SOP inquiries, one word, at fcdo.gov.uk. I just thought I'd throw that in because it happened to me very recently and I was somewhat taken by surprise. Maybe that's happened to some of you. Anyway, with that, I see I have overshot my time. It is past 10 to 3, and that's when we are supposed to be having a panel discussion to be followed by afternoon tea. So I'll keep my ugly mug on the screen, and members of the panel are cordially invited to join me. And I see that our two other speakers, Lawrence Youssefian, and oh, I think we've also got, yes, Jamil Dhanji, I think he's here as well. Oh, yep, fine. So all of you are welcome to take part in the discussion. And I think probably it's Samina who's got the most questions pending. She had to leave a number of inquiries at the end of her talk this morning. So maybe you would like to address those first of all, Samina.
Yeah, I think between Sarah and I, we've both been having, because we do a lot of EU work. So we've been between us joining heads to kind of work through some of the really difficult ones. So I think we've ticked on all the boxes to say we'd answer live. But I'm just going to start with a few easy ones, and then hopefully we can work our way down. Looking at the first query that came up, that was from Universe Solicitors, hello. And it was about an EA spouse who had arrived here as a visitor with children from a previous relationship and contracted marriage post December 2021. It's not straightforward. I mean, I think you have to look back to whether they've ever held any documents. But otherwise, I mean, they sound like they're excluded straight from the settlement scheme because the relationship, the marriage is post-December. I think you mean 2020, not 2021, but it's post-December 2020. But there's nothing to stop you from attempting to make those kinds of applications generally to see whether or not, if you've got full reasons and explanations to as to why, if there's any delay with the marriage. And I think that goes hand in hand with the query from Samir, which was the next query in relation to COVID delays, which interfered with the couple getting married. Again, with that, there's no reason, and I think Sarah and I agree on this, that there's no reason why you can't look towards the EU settlement scheme in the first instance to pursue what your options are and whether or not, how flexible the Home Office are going to be with reference to any EA applications. And if not, then I think it's finding the next option. And I think we've explored Article 8 applications and so on. But I think the first option is to see how far you can stretch the EU settlement scheme, how far you might be able to find compatibility challenges and so on. I don't know whether Lawrence has been dealing with a few EU applications, and Sarah as well, if anyone wants to add anything there in relation to that. Okay, and if anytime anyone does want to add anything, because these are all really interesting questions that we are as a team dealing with constantly, and we're exchanging ideas. So I'm happy for anyone to kind of jump in. We then have the other applicant who, this is, I think, anonymous, so it's the next one down the line. If there's any way to bring extended family members, this is someone where there is a minor child, so the the parents of an individual have come to the United Kingdom or have made an application to come, they're direct family members, they have another child, a minor child. So you're saying that they would be the extended family member of the EU national, and whether or not they could make an application or what their options are. Again, this is something where you can stretch, I think, the EU settlement scheme. Unfortunately, you've got parents who are included, then a minor child, and given that we've talked a lot about the welfare of children, safeguarding and well-being of minor children, then again, there's no reason why you can't make perhaps an application for this minor child at the same time as the parents, if the parents qualify, and then go from there as to whether or not, depending on the reasons they give, if they refuse, what challenges can be made insofar as whether there's a lacuna and incompatibility with the withdrawal agreement. When you're looking at the spirit, is all about family unity. So that's quite an interesting one as well. So the other one that gave us a little bit of trouble, and that Sarah and I have talked about quite a bit, is this one here, in relation to the visitors, individual who come in as visitors, and what their position would be. Sarah, do you want to take that? Is that all right?
Yeah, I will. I had to come off the webinar during the lunch break, so I can't see, for some reason it doesn't keep the questions that were posted before. So if I speak to that one and miss a detail, then please do correct me.
I'll post it up
But
again.
I think I remember the scenario. We weren't sure on that scenario. We weren't sure. I think the person is coming from Spain, the family member, the spouse, were married pre 31st of December 2020. And I think that's the two important factors to make sure you come within a family member of an EA national. The marriage does need to predate, otherwise you have to go down the road of durable partners and it all gets very complicated. The other fact I don't think that was entirely clear from the scenario is that the EA national who's been exercising their rights or residing in the UK needs to have been here before the 31st of December 2020. And if their spouse coming from Spain as a visitor, the provisions that were changed from the 6th of October do seem to benefit that category of persons, because joining family members were brought in to account for delays in family members coming, but also in family members having left the UK and having had their residence broken. So it was quite a complicated kind of remedial category that was brought in. But it does seem to make it a bit more simpler now that the visitors are not excluded from applying in that category. So certainly joining family members would be a good category to look at and could enable an application from here. But I think that's as far as we can go, because it's quite complicated looking at it, quite complicated looking at it full stop, but also looking at it on the hoof like that. But it seems to open up, certainly. And I think that was the purpose of it, is that I think they tried to regulate and kind of be too prescriptive, and that excluded quite a lot of people that otherwise had the rights.
So that's quite an interesting but complicated one, and it may need further facts if you want a more specific answer in any case. So I'll just move on to the next one, which was a lot of delays by the Home Office in the EU settlement scheme itself. A PAP doesn't work. I think the answer is then, of course, to issue judicial review proceedings. I think that's the only next step. The thing is to protect yourself. They're often conceding on these when you do issue, to remember that you're going to get costs back and so on. So it may be that if the client is financially, I'm going beyond the scope of the question, but if the client's financially in difficulties and thinking about what they could do, and this appears to be quite a strong case, they might want to look at CFAs and so on, because if you're going to succeed, if you're more than likely going to succeed, then the client may want to, and you may want to think about whether or not to pursue it, and be able to recover all costs once you succeed, and have even a consent order means that you would get your costs back.
Yeah. And just adding on that, two things. First, there's plenty, I think we've covered it in previous talks, there's plenty of kind of wording that's useful in the EUSS guidance, but also that's been kind of extracted from the withdrawal agreement to show, you know, that the Home Office has got to be proactive, can't look for reasons for refusal, that things have got to be worked through quite swiftly. So there's quite a lot of support to that in a JR if you have to take that step. Particularly in delay cases, because in delay cases, you know, we always wonder, well, is it long enough to do the JR? What's a delay? What is long enough to wait? But I think in the context of EEA, you know, if you go back to the 6 months processing time of EEA applications before, you know, we are sort of under a more, again, not generous, but you know, a nicer context that we can make use of. And secondly, it was only through a JR that progress was done for extended family members. So it, you know, it does work.
Yeah. And then that takes us to, again, there's another one which is in relation to someone saying something about silly refusals, you know, where there's a very minute issue that's been taken. Well, that's a matter of appeal. I think that's the best way forward. If they have a right, they should have a right of appeal with all the new applications and refusals. Anything refused after the 31st of January 2020 would have a right of appeal. So pursue it via a right of appeal. But your first port of call might want to be a reconsideration request. There's a specific email address for reconsideration. So that might be a really good option to resolve it without having to prepare and go to court in the first stages. I think there's a question which I've said I would answer live, but I'm going to leave. It's a very complicated question about retained rights and maybe come back to it a little later, but I'm going to deal with David Nelson's question about the extended family member of an EEA national who was in the UK before the 31st of December and made an application to the UKBA. He completed the wrong form, so he completed an EUSS application instead of an EA application. I think the first port of call again is to appeal and to see how far that can go or can be taken in terms of how flexible they might be given the error that's been made. And as long as you flag up the error, also look at whether or not, I think, they've held any other status before entering the United Kingdom. So you say he's entered before the 31st of December, he may well have applied and entered on Appendix EU-FP, which would, not Appendix EU, sorry, the EA family permit. So under the EA regulations, he may have had short-term entry into the United Kingdom. So yeah, that would really help to kind of take a full background, but I think the EUSS application can be appealed and then see whether if they've got a right of appeal, if it hasn't been rejected outright, but I think that's an option or a way forward essentially. And then I'm going to hand, so that's my questions done, and I think I can hand over to Sarah with the questions on nationality.
Thank you. So remind me, the question on nationality. Oh yes, there was one from Katerina about statelessness, and then what was the other one about EEA and being more restrictive? Yeah. Yeah.
What I'll do is I'll pop it in the chat for you, Sarah, so you can see it fully.
So dealing with Katerina's first on statelessness. Yeah, I think it probably arose, it's a good question because I think it picked up perhaps on my slide. I was a bit sloppy, so apologies on that. The slide, I think it was slide 8 of my talk, in terms of the exceptions to the good character requirement in nationality cases, relates to exceptions that only are registration routes. So there are various provisions that relate or are kind of have statelessness as a background to them in the Nationality Act, the 1981 Act. For example, if you're born here and you've always been stateless, or you are stateless, you can apply to register. That's for minor children as a British citizen. As far as I had a quick check, and as far as I could see, all the other provisions in Schedule 2 of the Act that are statelessness related have a background of other British nationality statuses. So British overseas citizens, if they don't have any other status, or if they otherwise would be stateless. So they wouldn't cover the scenario that Katerina gave. So a person who acquires the rights to permanent residence, for example, through being stateless, so through the Statelessness Convention and so on, and then applies to naturalize, is still subject, as far as I can tell, to good character requirement. I don't think I've ever had a case that would involve that, but as far as I can see, there's no exception to that. So thank you, Katerina, for your question and for picking that up. Otherwise, it was
popped it in the chat box. I can read it out if you wanted it.
Yeah, sorry.
Yeah, so it says, what if a child born outside the UK to a British citizen father, but the father is inanimate and the child is currently living with the non-British mother outside the UK? How do they go about with a right of abode application?
I don't know off the top of my head. It's a quick one. Born outside the UK to a British father.
Isn't the child automatically British if the father's British? So they don't need...
So the father is inanimate, meaning the father is British.
It says born outside outside the UK to a British citizen father, but the father is inanimate. So I'm not...
It means he's dead, doesn't it?
Oh, right, okay.
Okay, sorry. Sorry.
He's still British.
Yeah, so thank you. Yeah, that would be right. So it doesn't matter that your parent, whoever the parent is, whether it's the mother or the father, it doesn't matter that they're no longer alive at the time that you try and sort out your nationality rights. So it may matter in terms of documentation and proving relationship, depending on where you were born and, you know, if your birth certificate's accepted, that sort of thing. But as long as you can trace the child, the client, to their lineage, their parents, and the rights through them, and document that, then that's fine. And it would be potentially, the child would be British by descent. You don't need to go into right of abode. When I see right of abode, I get scared, which is why I said I don't know. But yeah, so that's that one. And then there's another question, I think, on the nationality front, which was effectively about CSI or exercise of treaty rights for European citizens. So I think, yeah, I can't answer the question like this, but it goes back to what we've both flagged in Samina and I in other talks, that two things. First is the nationality requirements in terms of good character, because they stretch longer, potentially your residence as an EA national or as a family member will be scrutinized potentially more, even if you then, you have obtained the PR, which you will have if you're applying for naturalization. And the second thing is, if you come to applying for naturalization having obtained settled status through the EUSS, again, that is currently being interpreted differently as permanent residence under EEA law by the Home Office in the naturalization application. So to give you an example, you could attain settled status under the EUSS after 5 years of living in the UK as an EEA national, and that residence wouldn't have been scrutinized as whether you've got CSI if you needed it, for example, or whether you had exercised treaty rights for the whole period. That is not necessarily carried forward in the naturalization application. So it's not necessarily more restriction, but it's more restriction because of the 10-year period. And it's just, I guess, a false sense of security potentially arising from the EUSS that then doesn't carry forward to the naturalization. So, you know, we had these issues before, but I think they're coming to the fore a bit more because of the confusions between the two. So I think that's...
There's another one for you, Sarah. It's about the child brought into, I don't know if you've seen it. I just said I'd answer
As
live.
an infant?
Yes. So if you can see that one. It's from Abby.
Yeah. So question mark whether they could have registered anyway as a British national. So because if the child was not born in the UK, and has subsequently lived here for a long time, then there could be registration applications to make, but discretionary ones. The one that is implied here is if you're here, if you've lived the first 10 years of your life in the UK, but it does require you to have been born here as well. That is by entitlement. So I see my friends Samina and Lawrence nodding, gives me great reassurance. So, you know, the fact that the parents didn't know, obviously a shame, but it may still have been a problem anyway. So you would be, depending on the immigration status of the child, you may be looking at immigration applications first if they don't have status, and or discretionary. No, if they're over 18, I think it would have to be naturalization now if they have got permanent residence.
There's one more which actually touches on both nationality but also EU.
Let's give it to Lawrence.
Yeah.
No. I think you guys are doing a great job. You keep going.
Come on, Lawrence. Okay, so I'll read it out, and then Lawrence, if anyone wants to jump in, please do. So the client first entered the UK in November 2019 on visit visa and returned to Spain in December 2020. Returned to the UK in February 2021 with a Spanish passport after being granted citizenship in February 2021. He applied under the EUSS scheme, but he was refused. Can he appeal the refusal decision? It sounds to me like he wasn't a Spanish national before entry into the UK. Is that how you guys read it?
I have to read it first. Sorry, I can't find it.
Oh, okay. I'm going to pop it
into
the chat box so you can see it, Sarah. Yeah, it sounds as though he wasn't a Spanish national before when he came as a visitor, and that was in December 2020, and then arrives as a Spanish national later. Well, he's not in the United Kingdom at the specified date of 31st December 2020. So I think that kind of excludes him from the EU settlement scheme.
So the only qualification to that is if he was so we don't know on that scenario, and the person asking question would need to clarify or take a note in terms of what needs clarifying from the client, because unless they were Spanish prior to December 2020, I mean, they might not have had a passport and they might have traveled on something else, but still being a Spanish citizen back then. Because a Spanish passport's only a travel document, it's not proof that they're Spanish. So okay, if they were Spanish pre-December 2020, can show that and can show that they were here before December 2020. If not,
So there is another one which is on EU nationals, and it says, can a stepchild of an EU national apply for EUSS family permits after June 2021? Father married to the EU national in 2019 and both granted pre-settled the same year. I think so.
I think that's so, yeah.
I think that sounds, yeah.
There was a lot of confusion, and I think it has been accepted by the government that there was a lack of awareness that children had to apply under the USS scheme as well. So I think there are still to come quite a lot of late applications potentially from children.
Okay. And then there's a really interesting one, proxy marriages. Anyone specializing?
Guys, come on. Easy question.
So this one is, can a spouse of an EA national with pre-settled status apply to join her husband after the 30th of June 2021? They married by proxy in September 2020.
I mean, I guess it depends on whether the proxy marriage can be accepted, but potentially yes. I mean, it's worth looking into. Proxy marriages, as far as the UK is concerned, again from memory, are recognised if they are lawfully carried out in the country that they're contracted in, right?
Yeah, there's that line.
So as long as that box checked, the marriage was then contracted before December 2020. So yeah, potentially.
Okay, brilliant. And then there's another question from Katerina. Is that a question we've answered already? So if an EU national visitor joined the pre-settled spouse in the UK wants to make an application, oh, that is the question we did answer early. So thank you, Katerina. Okay, I'm just trying to run through if there's anything else we've missed, if anyone can spot anything. There are a couple of questions, and these are in relation to no recourse to public funds. I can pop that, and this is a question from Abby. I can pop that in the chat box so you can have a read, but Lawrence, if you want to have a look at that as well. It's basically, oops. So it's, I'll read it out. The case where leave to remain was granted in 2012 for an African family with nil recourse. I'm assuming that's no recourse to public funds. By 2014, the family applied for the removal of that as requested by the Housing Department. This was granted 2 weeks to the expiration of leave. Subsequent application was denied for late submission, though was applied timely, but was returned for reason of fee waiver. Applied for Home Office, held the renewal until 2018 for one child and 2019 for the parent after a judicial review. Home Office cannot find the grounds or documents for parent. On what grounds can we submit the renewal application? Ooh. It's a nice loaded question, lots of different components with a really difficult history. Any ideas?
It's one for Lawrence, come on.
We have come here to discuss one thing and one thing only, which is deprivation on deception grounds. It's difficult, isn't it, to have to give advice on the hoof?
Yeah, I mean, that's a really difficult question in terms of the whole immigration, the complex immigration history, for sure. I think that it's something that would require a lot more detailed consideration. So I think I'm going to say that we're not going to answer that particularly. It's too specific. But we're all available in terms of, we have our email addresses there. So if you do want to get some informal but also instruct formally, the addresses are there to be able to reach out for us. Okay, so let's have a look at anything else that's come in. For Sarah Pinder, it's from Shahid Hussain, and it's can a victim of domestic violence who got ILR after 2 years of his or her arrival apply for naturalization after 3 years, or is it 5 years stay in the UK?
So I only touched on 3 years in terms of the residential requirements for naturalization. And again, to contrast that with the 10 years of good character kind of period that's looked at. So again, there's little detail, but a victim of anybody can apply for naturalization on the grounds of 3 years residence in the UK, as long as they are married to a British citizen. But they need the support of their spouse, as far as I can recall. So you need to submit the marriage certificate to show that you're married to a British citizen, and the confirmation that that person, your spouse, is British as well. So in the context of a DV victim, I suspect that that wouldn't be relevant unless they've since remarried, and that could be the case. So effectively the residential period, being here for 5 years lawfully, is cut to 3 for those who are married to British citizens. That's the nub of that requirement, and can apply to anybody, however they got their ILR, but is dependent on their spouse being British. So I hope that clarifies that.
Sorry to intervene, folks, but we could go on. You know, there's so many questions that could be answered, but we really are running short of time now. So it's 3:20, and I think we'll have to take our tea break now. And for those who haven't had their questions answered, I'm really sorry, but we're supposed to finish at 5, which we're not going to do, I'm sure. But we've got to hear from Lawrence Youssefian, who's waiting patiently to come on, and then Jamil Dhanji after him. So I don't know, it might be possible for Sarah or Samina to answer questions from the chat box or the Q&As, but I don't think we're going to have time for any more live questions. Sorry about that. So let's take a break now for 10 minutes. And
Richard, let me know if you wanted me to just start or not. Right. So welcome everybody. I understand that it's 3:30 and probably the last thing you want to hear is about deprivation.
oh, sorry, I didn't mention you earlier on, Lawrence, but yeah, it is time to start. So thank you very much.
Okay, great. Can you hear me?
I can certainly hear you.
Brilliant. Thank you. All good. So as I was saying, this is the seminar on deprivation of citizenship on deception grounds. Can you see my slides as well, Richard? Can I just double check?
Yep, I'm hearing you and seeing you, and yep, I can see your slide very well.
Brilliant. Thank you very much. So first off, I just want to say really, really well done to Samina and Sarah for answering those questions on the hoof. It's really not easy to answer questions, Q&A, particularly in that way. So really, really impressive work. And thank you, Sarah and Samina, for answering all those questions, basically. So deprivation of citizenship on deception grounds under section 43. So we are considering the British Nationality Act 1981. And this is a issue that I think a lot of people are now facing now, with increasing number of decisions being taken under section 43 of the British Nationality Act. What I'm going to do is I'm going to very, very quickly go through the legal history in the sense, and again, kind of like an outline, considering the British Nationality Act, and then the case law, how it was before Begum and how it is since the Supreme Court case of Begum, latest case law on Chiseri in the upper tribunal. And then I'm going to consider the individual elements of section 43. And finally, briefly discuss the discretionary provision of section 43 and article 8 and how that should be approached. So section 43, you will know that section 40 subsection 2 is in relation to the section states power to deprive somebody of their British nationality because it's conducive to the public good to deprive them of so. But here we're only concerned, I'm only considering rather the deception grounds point, which comes under section 43. So it says Secretary of State may, let me see if I can find a highlighter, great. Secretary of State may, by order, deprive a person of a citizenship status which results from his registration or naturalization if the Secretary of State is satisfied. That's important, and I'll tell you why. I'll tell you why that's important. Secretary of State is satisfied that registration or naturalization was obtained by means of fraud, false representation, or concealment of a material fact. So two things to note, or three things rather. One, may, so immediately we know that this is a discretionary provision. Secondly, obtained by means of is clearly important because it signifies, and we'll look at this in a moment, it signifies the fact that fraud, false representation, or concealment of a material fact had to be used in a material way to obtain citizenship. And thirdly, we have to consider these and what these mean. So that's section 43. The law as it was before Begum was really pithily stated in KV Sri Lanka in 2018. Essentially, this is what it was. So KV at paragraph 6 held that when you're considering an appeal under section 40A, which is appeal provisions of the British Nationality Act, the tribunal is not reviewing the Secretary of State's decision, but it is a full reconsideration. So it was the tribunal had the power, much like in any appellate jurisdiction, decide for itself the elements we've discussed previously. So the discretion, the tribunal can consider whether it was obtained by means of deception, and also whether those deception points are actually proved. That was all for the tribunal to decide. And it says it is thus for the tribunal to find the relevant facts. And again, for the tribunal to establish whether citizenship was obtained by one or more of the means specified in that subsection. And then again, it was for the tribunal to decide whether the Secretary of State's discretion to deprive the appellant of British citizenship should be exercised differently. That was again for the tribunal to determine. The tribunal must still consider whether discretion should be exercised differently. Obviously, in considering whether the tribunal should exercise discretion differently, the court in KV had held, rightly so, that the Secretary of State view should still be given very considerable weight. And that's true in any area, really, where there is a discretion afforded to the Secretary of State. The courts should be giving very considerable weight to the Secretary of State's initial view as to how she decided to exercise that discretion. But after KV came the Supreme Court case of Begum. And when Begum first came out, this is the case concerning Shamima Begum, who you will all know is stranded outside of the UK, and the Secretary of State then Sajid Javid tried to, or did seek to deprive her of her British nationality, and a number of legal challenges were mounted against that. I'm not going to go through the history of that, but I want to just very quickly go through Begum, particularly what it held, because Begum did change the landscape of deprivation cases quite considerably, or so we thought initially. When it first came out, everybody was quite concerned as to how Begum is going to be applied in the real world immigration tribunal and SIAC as well. Another thing to consider is that Begum didn't actually consider a section 43 provision, but it considers section 42, which is conducive to the public good ground. Now, the Supreme Court says the opening words, the Secretary of State may, indicate that decisions under section 42 are made by the Secretary of State in the exercise of his discretion. The decision is one which Parliament has confided to the Secretary of State. In the absence of any provision to the contrary, it must therefore be exercised by the Secretary of State and by no one else. There is no indication in either the 1981 Act or the 1997 Act in its present form that Parliament intended the discretion to be exercised by or at the direction of SIAC. SIAC can, however, review the Secretary of State's exercise of his discretion and set it aside in cases where an appeal is allowed, as explained below. The statutory condition must be satisfied before discretion can be exercised is that the Secretary of State is satisfied deprivation is conducive to public good. The condition is not that SIAC is satisfied that deprivation is conducive to public good. The existence of a right of appeal against Secretary of State's decision enables this conclusion that he was satisfied to be challenged. It does not, however, convert a statutory requirement that the Secretary of State must be satisfied into a requirement that SIAC must be satisfied. That is a further reason why SIAC cannot exercise discretion conferred upon Secretary of State. So, and then Begum goes on to consider, and we're going to consider what, gosh, I keep doing this. Begum goes on to consider why or how, nevertheless, the courts can be useful, essentially. But what's interesting here, when you look at the reasoning in Begum at paragraph 67, 66 and 67, the reasoning here is that the Act specifically stated that, wow, I am not working this tech well today, apologies. Right. Begum specifically stated that because of the words, if the Secretary of State is satisfied in the statute, that meant that it wasn't for SIAC to satisfy itself. It was for the Secretary of State to satisfy herself or himself. And even on an appeal, that doesn't change. But again, bear in mind, this is in relation to section 42, not section 40 subsection 3. But when we go back to what does section 40 subsection 3 say, it says the Secretary of State may by order deprive a person of a citizenship status. So again, may, obviously, this is a discretionary provision, but then it says, gosh, this is so messy. Great. It specifically says, if the Secretary of State is satisfied that the registration was obtained by means of fraud. So again, what we see is that even though the Supreme Court was considering section 40 subsection 2, its reasoning may be directly applicable to also section 40 subsection 3, that in an appeal, the Secretary of State's decision can be only challenged on review, administrative law grounds, because the court won't have to consider whether the court is satisfied with the use of fraud, but it's still the Secretary of State even on an appeal. So that's why paragraph 71 is actually quite important, because paragraph 71, the Supreme Court tells the lower courts how to go about considering an appeal against section 42 or potentially in section 43. So for instance, it can assess whether the Secretary of State has acted in a way in which no reasonable Secretary of State could have acted, or has taken into account some irrelevant matter, or has disregarded something to which he should have given weight, or has been guilty of some procedural irregularity. These are public law errors, right? So the Supreme Court is saying, consider the public law errors. And then it says, second, it can also consider whether the Secretary of State has erred in law, including whether he has made findings of fact which are unsupported by any evidence or are based upon a view of the evidence which could not reasonably be held. And then it says third, fourth, and so forth. Breach of legal principles, such as Human Rights Act, Section 6 and Article 8. But when considering a breach of Article 8 and human rights, when considering that, the court has to make its own independent assessment, because the tribunals and the courts are bound by Section 6 of the Human Rights Act 1998 to act in a way that is in accordance with the European Convention of Human Rights. So when it comes to the European Convention of Human Rights and the Human Rights Act, then the courts have to consider for themselves. It's not a review, it's a full-blown merits appeal when it comes to Human Rights Act. Then we have, so there was a bit of confusion after Chiseri came out, and there was a case of Lachi in the Court of Appeal, which really didn't consider Begum because it wasn't asked to do so in any detail. So Chiseri in the Upper Tribunal, which came out about a month and a half, 6 weeks ago, 5-6 weeks ago, is the latest authority we have. My understanding is that there is permission to appeal pending with the Court of Appeal, I think by the appellants, so not the Secretary of State. So that's something that is pending. And watch this space, because it may very well be that Chiseri was not right, was not decided correctly. I'm not entirely convinced that Chiseri was decided correctly, but for the time being, Chiseri is authority. And Chiseri seeks to give guidance on what is the appropriate way to proceed moving forward. So the tribunal must first establish whether relevant condition precedent specified in section 42 or 3 of the 1981 Act exists for the exercise of the discretion whether to deprive the appellant of British citizenship. This requires the tribunal to establish whether citizenship was obtained by one or more of the means specified in that subsection. In answering the condition precedent question, the tribunal must adopt the approach set out in paragraph 71 of the judgment in Begum, which we already considered, which is to consider whether the Secretary of State has made findings of fact which are unsupported by any evidence or based on a review of the evidence that could not reasonably be held. If the relevant condition precedent is established, that means if it is accepted that if it is accepted that there was fraud or deception and nationality was obtained by means of deception, and there is no reason why discretion should be exercised differently, so all the elements of section 43 is satisfied, then the tribunal has to decide whether the rights of the appellant may or any other person are engaged under the European Convention of Human Rights and usually Article 8. And again, we said that the tribunal has to decide this for itself. So then you have to consider the reasonable foreseeability of the consequences of deprivation, which we'll go through in a brief moment. And then again, this section, 4, 5, and 6, and 7, these are all to do with the exercise of discretion on Article 8. And essentially, we know so here it talks about delay, the relevance of delay, which is relevant. We know that delay is relevant. In Lachi, in the Court of Appeal case of Lachi, delay was relevant, and the delay in that case was the appellant was informed of potentially going through deprivation proceedings, but the Secretary of State never took that decision for many years. And that delay it was said by the Court of Appeal in Lachi that delay made it disproportionate to deprive that individual of their nationality. There is another kind of delay, which Haisaj in the Upper Tribunal considered, which is there was a period before previously where the Secretary of State considered that a grant of citizenship based on a false nationality, for instance, was a nullity of that citizenship. So they didn't need to deprive, no deprivation decision needed to be taken. That obviously has been found to be wrong by the Supreme Court. And so there was a delay where the Secretary of State was simply not taking any decisions until the Supreme Court took a decision as to whether the Secretary of State's view on nullity was correct or not. That delay, however, Chiseri has held in line with Haisaj, not normally be relevant in assessing the effects of delay by reference to the second and third of Lower Bingham's points in paragraph 13 to 16 of EB Kosovo. Oh. So, where are we? The tribunal first has to consider section 43 is engaged by deciding if nationality was obtained by means of fraud. if section 43 is not established, the 3 elements, then the appeal has to succeed. And if it is satisfied, then, as we said, we go on to look into discretion and breach of Article 8. Now, obtained by means of fraud. We've already said the tribunal has to determine the factual basis by reference to paragraph 71 of Begum. These are public law errors, but then often what's interesting is that often you can argue that any attack, line of attack that you have in relation to the Secretary of State's decision, that is a public law error, because the Secretary of State probably took into account irrelevant factors, maybe failed to take into account some relevant matter, such as an oral evidence that was given at the hearing. That would be a relevant matter. So it's a little difficult to see how it actually works in practice, because the Secretary of State almost always would not have considered the appellant's oral evidence in court, because obviously the appellant wouldn't have given evidence before a decision to deprive would have been taken. So it's interesting how you can always use that. But Secretary of State may have not taken into account her guidance properly, her Chapter 55 guidance, which I will touch upon in a moment. There is usually a way to fit your line of argument and challenge within paragraph 71 of Begum and say that your criticism is, in truth, public law challenge, or analogous rather to a public law challenge in conformity with paragraph 71 of Begum. As I've said here, additional documentary evidence in the appellant's bundle may have also not previously been considered by the Secretary of State. So really, as Chiseri stands at the moment, paragraph 71 of Begum and the way we thought things are going to be very complicated may not be true at the moment. We'll see how the Court of Appeal, if permission is granted, we'll see how the Court of Appeal will deal with it. So when we're considering deception, there are 2 steps to take. First of all, was there an actual use of deception, dishonesty? And then if there was, well, was that still nevertheless material to the acquisition of nationality? Just because you use deception. So the classic case at the moment I'm running through, and I've been instructed a number of deprivation cases and appeals, and most of them, not all, but most of them have to do with the type of case where an individual comes to the UK, claims to be Albanian national, claims to be a Kosovan national, doesn't get usually asylum on that basis, but gets some form of leave, such as an unaccompanied minor of some sort, or just on the basis of discretionary leave. And then they are subsequently granted indefinite leave to remain on the basis of legacy or some other concession, and then naturalize off the back of that. And then later on, it's discovered one way or another. They try to sponsor a spouse, they try to bring in a child or a parent or something, and it's then discovered that they were actually not Kosovan, but instead Albanian. And the Secretary of State would say, well, look, you use deception because you lied to us by saying that you were Kosovan when in fact you were Albanian. So in such a case where first you need to take instructions from your client. Are you actually, is that true? Is the allegation true? Are you actually Albanian? If they say, no, I am actually Kosovan, then you're not accepting the use of false information or deception. And so you challenge that on classic way of challenging deception allegations. You adduce evidence, you give detailed witness statements, you try to obtain as much evidence as possible to show that you are who you said you were. You have to also, another element is that there has to be an intention. So even if the information is false, if there is no intention to deceive, then that still doesn't satisfy the deception requirement. So you have to also even if they say, yes, the information I've provided is false, you have to understand and take instructions. Well, why was that information false? There may have been an innocent error or genuine omission. And the Secretary of State in her own Chapter 55 guidance accepts that an innocent error or genuine omission should not lead to deprivation. So it's important to take instructions on both points. If both are accepted, so for instance, let's take the classic case of an Albanian national who claimed to be Kosovan. In that case, if they accept that they are actually Albanian, so then it's going to be difficult to argue that they didn't use false information because their nationality is false, and that they didn't have an intention to deceive. Now, if they come as a child, there's a subsection of that which I will deal with very briefly, but generally speaking, it's not going to take you too far if you're an adult. I have had recently actually a case where we disputed the use of false information altogether. So we just focused solely on the Secretary of State's allegation of deception, the actual use of false information, to prove that actually the information provided was not false. The information provided to the Secretary of State. In many ways to do that, and that was really important for us to do that. And bear in mind, if the Secretary of State is alleging deception, the burden of proof is on the Secretary of State. So she needs to be put to strict proof to prove on the balance of probabilities, obviously, that the information provided was false. If you use deception, so if you are Albanian, let's say, and not Kosovan, again, I'm just using this example because I've seen it quite a number of times. There are many different examples with many different, some people have lied about their nationality, some people about their age, about different things, the basis of their asylum claim, X, Y, and Z. The next question is, just because you use deception actually is not enough, because you have to also, as the statute requires, by means of fraud. So there is a further step. Now, this is quite an important step because in many cases, you're going to be driven to accept that deception was used. And so where the battle is going to be is going to be, well, yes, we did use deception, but it wasn't relevant to naturalization. And you can sometimes win cases on that. I've won a couple of cases on that basis. Your starting point should always, always, always be Chapter 55, the Nationality Instructions on the Deprivation and Nullity of British Citizenship. This guidance, I think the latest is 2017, December 2017, is the most important guidance. It's very helpful. There is a lot in there, and sometimes Secretary of State doesn't even take into account her guidance properly. So always start with this and read it very carefully. So I'm going to just run through some aspects of the guidance, which is helpful. So I said deception by minors. Paragraph 55.7.8 of Chapter 55 specifically says that use of deception by minors. So for instance, if the child came to the UK, if the individual came to the UK at age 12, and they said they're Kosovan when they're actually Albanian, but they had a parent or a guardian, and they say, well, this is who told me. They told me to say this, or my agent said that I should say I'm Kosovan, or agent actually said that the appellant is Kosovan, then they are assumed to be not complicit in the lies. And that assumption continues until they hit their 18th birthday. And unless there is strong evidence to show that there was some kind of coercion of some sort, then any lie you've said after the age of 18 will be held against you. And that's sometimes worth looking at to see, well, at what point did the individual turn 18? And so which lies, what previous deceptions can be disregarded? Sometimes they'll be granted indefinite leave to remain when they're a minor. So then the only deception would have conceivably been at the time of the naturalization application. Another interesting point, concealment of material facts. So this is why, for instance, this is quite understanding chapter 55 is important. Post-application deception should not lead to deprivation. So I am representing an individual at the moment, for instance, where they made an application for naturalization. They said that they're a person of good character and signed it off and everything. And then whilst the application was pending, they committed an extremely serious criminal offense while the application was pending. This offense didn't come to light. The application was approved and they were naturalized as a British citizen. 8 years later, it came to light that he had committed an offense whilst he was waiting for that naturalization application being approved. He was charged with an offense and he pleaded guilty. Now, the Secretary of State took the decision to deprive the person of their nationality on the basis of deception because of concealment of material facts, because they said, well, look, you committed this offense whilst the application was pending and you had an ongoing duty to inform us of any change of circumstances, which is correct. Now, we're challenging this in the upper tribunal. We've obtained, they lost the appeals, and then I was instructed for the error of law, and we've obtained permission on quite an interesting point about privilege against self-incrimination, but I'm not going to go into that now. But what's interesting is that the guidance specifically says that the Secretary of State will not deprive a person of their British citizenship if the fraud postdates the application of British citizenship. And we know fraud, the word fraud is defined as both false representation and concealment of material facts. So on the basis of it, and it's interesting because this specifically says application, it doesn't say grant of citizenship. So on the face of it, and regrettably, this point wasn't argued by whoever represented in the first tier tribunal, this Secretary of State's guidance, because in my client's case, their concealment of material fact only happened after the application whilst he was waiting. So arguably they come under the guidance and no decision to deprive should have been taken. But this is why it's important to always consider chapter 55 and read it very carefully. Let me just check the time. Right. So fraud and false information. This case is extremely important, Sulaiman. This case is your friend. This case is actually your best friend at the moment, okay? So Sulaiman was a case where the appellant entered the UK and lied about his age and made himself about 2 years younger, which meant that he was a minor at the date of entry. If he had told his true date of birth, he would have been an adult. He claimed asylum, which was refused, but then was granted discretion leave to remain as an unaccompanied minor. And then he eventually was granted an extension. And then, his extension application was outstanding for a very long period. So then he was considered under the legacy scheme and then was granted indefinite leave to remain. Thereafter, naturalized as a British citizen. His date of birth came to light, and then so a decision to deprive was taken. So on the face of it, what it seems like this individual directly benefited from the fact that he lied, because he lied by making himself 2 years younger, and as a result was granted discretion leave to remain, and as a result was granted indefinite leave to remain. But what's significant in Sulaiman is that there was a Home Office case note which said that the grant of indefinite leave to remain had nothing to do with the appellant's age. And that was significant because that means the age was not relevant to the grant of citizenship. So Sulaiman said that it permits the Secretary of State to make a deprivation decision where the registration or naturalization was obtained by means of fraud. So there has to be some causative link between the action or omission and the obtaining of citizenship. And it has to be operative concealment. So that concealment or fraud has to have been materially relevant to grant indefinite leave to remain. And it says, I therefore agree with Mr. Yo's submission that impugned behavior must be directly material to the decision to grant citizenship. Well, what is then What is then material? Well, in Slayman, it was considered that the delay essentially broke the chain of causation. Even though he had lied about being 2 years younger, the reason he was granted indefinite leave to remain was not because of his age, but was because of the delay. There was a delay of 5 years and was considered under legacy. And that was said to have broken the chain of causation. In a false nationality case, where you say, for instance, you are Kosovan when you're actually not Albanian, a similar argument can be said if they're granted indefinite leave to remain not on the basis of their nationality. So it's quite important in those cases to ascertain, well, what is the basis of them being granted indefinite leave to remain? On many occasions, it's because similarly, it's because of legacy. So they will say the grant, look at the grant letter, indefinite leave to remain. What does it say? It will say because of a delay, because of your length of residence. It usually won't say nationality. And so that is quite a helpful way to go about attacking a decision to deprive your client of their nationality. Really important. Indirect or a loose link to grant of citizenship is not enough. And in Slayman, that 2 years was a loose link because the delay broke the chain of causation. So see what breaks the chain of causation. I've also said that look at the evidence that any previously was not granted as a result of deception. Always make a subject access request. This is extremely important, because the subject access request might give you an explanation as to why indefinite leave to remain was being granted. And you can rely on that and say, look, the nationality wasn't even a factor. In some cases, and I had a case where the Secretary of State even considered and said in the case notes, potentially, it said, well, the appellant might potentially be Albanian because he had traveled to Albania. But that was not relevant. And they had specifically said that. Or in another case, they had said something similar and said this should be noted in the future. And we relied on that to say, well, look, if it was relevant, they would have considered it. They would have considered the probability of the appellant actually being Albanian. But the fact that they didn't, and the fact that they took no action was suggestive of the fact that it wasn't a relevant consideration for the acquisition of ILR. The Chapter 55 guidance says, gives examples, and these examples are also helpful. So for instance, where a person acquires indefinite leave to remain under concession, the fact that we could show the person had previously lied about their asylum claim may be irrelevant. So there is the question about relevance. What is the reason for indefinite leave to remain being granted and thereafter citizenship? The fact that they have concealed criminality or other information relevant to an assessment of good character or immigration history and another identity is not material to acquisition of ILR or citizenship, then again, deprivation shouldn't be considered. Always focus on, well, not always, but consider focusing on the grant of ILR first, because that's where you can usually find a break in the chain of causation. What then happens, and in recent cases, what the Secretary of State argues or tries to circumvent, the way in which she tries to circumvent the case of Slayman, it says, well, it may have not been relevant to the ILR, but the deception was relevant to the good character requirement. If they had told us that they are Albanian at the point of the naturalization application, we would have refused it on the good character requirement grounds, and therefore it can't be said that the lie was immaterial. And that's the fallback argument against Slayman, because they would have fallen foul of the good character requirement. Now, the first thing to do in faced with such arguments is to check the good character requirement guidance and the application form at the date of the application and decision. Many of our clients, their British nationality may have been granted many, many years ago, and the application form, the guidance has changed quite considerably. So look at what it says, what the good character requirement says. For instance, the good character requirement in 2012 said it is irrelevant whether deception was material to the grant of leave or not. And the Secretary of State may rely on this and say, well, look, the fact that deception was immaterial is not relevant because the good character requirement specifically said that whatever lie is used, that would be material and that would lead to refusal. But this may not be included in earlier guidance and forms. And I in fact know that the earlier ones don't. So always check the relevant good character requirement. I know I'm running a little over, so I'm going to try to finish ASAP. Actually, am I? Yeah, I am a little, almost, I think. So the trouble with the Secretary of State's argument about good character is that, and I've set it out here in my slides. Basically, the Secretary of State's argument would mean that any lie is material, because this is what the good character requirement says. Any lie is material to the grant of citizenship. Sorry, any lie, whether the lie was material or not in relation to the earlier grants is irrelevant. So that means all lies are relevant to the good character requirement. But on that logic, that would essentially remove the statutory wording of the requirement that there has to be evidence that citizenship was obtained by means of, because you are saying now everything is relevant. But that's also squarely not what the guidance says. Chapter 55. Chapter 55, we looked at the example where it considered circumstances. So for instance, even this example given by the Secretary of State, this individual who lied, who would have lied about their asylum claim, says that it's, the guidance says that it's irrelevant. In those circumstances, if it is irrelevant, then we shouldn't deprive somebody of their nationality. But on the Secretary of State's argument, even this individual, because they lied and that lie would have been relevant to the good character requirement, should be deprived. So the argument is inconsistent. And don't forget, this individual who acquired ILR under a concession and who had lied about their asylum claim would have had to make an application for naturalization and would have had to satisfy the Secretary of State of good character, that he or she is of good character. So they too would have been caught by the good character requirement. But the Secretary of State specifically says in these circumstances, they shouldn't be deprived. So what I have seen in my experience in court is that Secretary of State actually just simply doesn't address this directly contrary guidance. She relies on her good character requirement, a good character guidance rather than chapter 18, and ignores chapter 55. Don't let her do that in court. Always go back to chapter 55. Take the judge to chapter 55 and say, well, how do you propose to reconcile that? The Secretary of State has to reconcile that. It's not for the judge to reconcile an apparent contradiction. And this is actually a point that I am in the upper tribunal for at the moment. We'll see how the upper tribunal deals with this point. So
I think that might be it, Lawrence.
Yes, I know that I've overshot my time now considerably.
Oh, not really. Actually, you were down until 4:10, and we actually got started with your talk late, so you've done very well.
Do I still have time then?
Oh, well, actually,
it's just
it would be good if we can finish not long after 5, because our end time is meant to be 5 o'clock.
Well, what I'm going to do then? No, this is my last slide. So what I'm going to do, I'm just going to leave this, and I'm just going to say, look, in discretion is very difficult to now challenge on grounds of irrationality. So focus on Article 8, European Convention of Human Rights. Look at the reasonable foreseeable consequence of deprivation. Look at limbo. Look at the effect of deprivation on the best interest of the child, and look at delay. These are some of the things to take into account. So those are, sorry for the last slide, I haven't had enough time to go through it properly, but hope it was an instructive presentation on deprivation. I don't know if we have any time for questions. I don't think we do, based on what I've just heard. But if anybody has any questions, feel free to email me here, and I'm happy to answer any questions. Thank you very much.
Thank you very much, Lawrence. I guess if you don't mind people using the Q&A or chat box, if you wanted to type a couple of answers if they're coming through at the moment. Otherwise, as you say, people can send you an email. And thank you very much for offering that facility, and indeed for being very succinct and bringing your own most interesting talk to an end. So thank you very much indeed for your contribution.
No, my pleasure.
And now we find ourselves in company with our last speaker from Goldsmith Chambers again, Jamil Dhanji, and he's going to be giving us a practical guide to judicial review in immigration law. So without further ado, let me hand over to you, Jamil.
Thank you, Richard. And Richard, before you disappear, can you, just as last time, make sure that if I'm not doing the technology properly, can you please just let me know, pop back on the screen and tell me, because I think the first time I presented, I had some difficulties. So please do interrupt if people are having difficulties seeing my slides. But I hope
Sure thing. If I can't hear you or see the slides, I'll let you know straight away.
Thank you. And nice to see you all virtually, obviously. Just a word of warning. I have had to make some arrangements to deliver this presentation shortly after finishing in the tribunal in Manchester. So I'm in a WeWork pod, a sort of temporary office that I've been given for an hour. And so apologies to everyone if when it gets to 5 o'clock, if I get turfed out of this room, then that will signal the end of my presentation. And I know that I'm the last speaker today, so undoubtedly it will probably signal the end of today's wonderful series of presentations. But let me do as much as I can cover in the time given to me. So what I want to try and do in the next 40 minutes is provide you with a practical guide to judicial review in immigration cases. I'm very conscious that you will all conduct this, that the level at which I pitch this is obviously something that needs to cover some basic principles, but also I hope engage in some more complex aspects of bringing JRs in immigration law cases. So I hope I'm going to strike that balance correctly. Just as with Lawrence and with the other speakers, if you have questions at the end, and if I don't have the opportunity to cover all of your questions, please do email me. Clearly, this is a really broad topic area. So just moving through then to my slides, I wanted to begin by revisiting some basic principles. In addition to the work that I do at the bar, I also teach on the GDL, the LPC and the BVC, or the BPC, I think it's now called, at the University of Law. And one of the things that we cover at the very start of the public law module is the separation of powers, the rule of law, parliamentary sovereignty, all of these things that I know you will have all covered many a year ago when you first entered into the world of law. But when we return to those principles, we remember the important role that judicial review actually has in the working of our constitution. What judicial review is, it's the rule of law in action, self-evidently, but sometimes we forget. You know, it's the way in which the judiciary discharges the constitutional responsibility it has of checking the power of the executive. And I think it's worth remembering that when we start addressing the issue of best practice in judicial review, because really that is what every judge sitting hearing a judicial review claim will be thinking. To what extent am I checking the power of the executive where the executive has abused that power? Or to what extent am I being asked to step into the shoes of the executive and make decisions that really should be made by the government or by public bodies? And I just thought it would be a good idea to start by addressing that principle. Then when we work through what we do when we are thinking about bringing a judicial review claim, we need a target. What is it that we're actually seeking to challenge? Is it a decision? Is it a series of decisions? Is it a failure to make a decision, a delay in making a decision? Is it a system that we are saying is unlawful, such as the detained fast track, or the way in which the NRM and the single competent authority makes decisions in trafficking cases? Identify your target. Identify what it is you're saying that the public body has done wrong. So what is your ground of judicial review? Conventionally, we have a threefold division. So illegality, irrationality, procedural impropriety. But you'll know from your practice that that's not a closed shop. The grounds that you can run in a judicial review, dynamic. You can add to that list grounds like legitimate expectation. There's been a push in many cases to potentially add the ground of proportionality. And within the conventional grounds, you have a series of ways in which you can frame your grounds. You can argue that the public body in question hasn't considered all relevant considerations, taken account of irrelevant considerations, failed to consult, fettered their discretion. So you'll know from your practice, it's not as simple as saying these are the grounds that you can run in a judicial review, but identify clearly what your grounds are. And in terms of best practice, when you're drafting, in a list form, make clear what the grounds you're running are in the case that you're dealing with. I'm going to spend quite a lot of my time dealing with something called the duty of candor that, of course, you'll be well aware of, but that's very, very important when considering the next point. There is an expectation that judicial review proceedings will be conducted with a high level of procedural rigor. Here, as I said, this is the judiciary stepping into the realm of checking the executive. And if they're going to be doing that, they need to ensure that proper procedures have been followed. So naturally, the correct forms need to be used. The fees need to be paid. Timelines need to be adhered to, and things need to be properly particularized. So if you've got an argument, it needs to be there at the start in your grounds for judicial review. And if you're going to change your argument, you need to formally apply to amend your grounds. I'll come on to address amendment shortly. But at the same time, judicial review recognizes that there is a need to be flexible within the procedure, because of course here, what we're dealing with is ensuring that justice is secured. And that is going to be the touchstone for the relevant court. So judicial review is colored by the ability to be procedurally flexible. But at the end of the day, materiality is going to be a principle that will permeate throughout. So if there is a potential unlawful act, but it doesn't actually lead to a different outcome, had it not been there, it wouldn't have made a difference. The court is unlikely to give relief. You'll, I'm sure, have seen in potential refusals that you've had in the past, JR is a discretionary remedy. The unlawful act here is not material, therefore we're not granting relief. So even if there is an unlawful act, that's not necessarily enough. So with those basic general principles having been touched upon, let's move on to deal with one of the meaty topics I wanted to address, the duty of candor. Now, this is a principle that I'm sure, and I certainly hope that you all have at the front of your minds when conducting work in judicial review cases. I mean, what is it? What is the duty of candor? It is essentially the responsibility on claimants and their lawyers and defendants and their lawyers to set out all of the relevant facts to the court, whether they support your claim or undermine your claim, so that the court has the full picture. I'll give you the example of somebody that might make a fresh claim for asylum to submit further representations, asking the Home Office to treat those submissions as a fresh claim. The Home Office refuses, says that the test in 353 hasn't been met. You're bringing a judicial review. You know of previous determinations that were negative to your client. Perhaps the respondent hasn't actually addressed those determinations in the refusal decision. They're relevant. If you have them in your possession, you should be disclosing them as part of your bundle. If you know of their existence, if you know that there are these previous determinations, you should be including those in the facts. It may not assist, it almost certainly won't assist your client, but it's part of your duty of candor to ensure that you are making full and frank disclosure to the court of all material facts. It's not just the claimant that has the duty of candour. Of course, the public body here for us, the Home Office, has the same duty. In the case of Huddleston, which is a 1986 case, the Master of the Rolls at that time, Lord Donaldson, described the judicial review process as one of partnership based on a common aim, namely the maintenance of the highest standards of public administration. He went on to say, and I find these words are quite useful at exemplifying the point I'm making, JR is a process which falls to be conducted with all the cards facing upwards on the table, and the vast majority of the cards will be in the authorities' hands. So on these slides, I've given you a few examples of where the duty of candour has been addressed, primarily in the immigration context. The first bullet point deals with the pronouncement that the duty of candour obviously applies to claimant lawyers, and then the next two deals with the duty of candour being borne also by the Secretary of State. In the final bullet, the one that's now hopefully on your screens, this was quite a clear telling off of the Home Office by the upper tribunal, where the upper tribunal criticised the Home Office for engaging in what it described as trench warfare. Obviously, these are adversarial proceedings, and clearly each side is going to want to ensure that their interests of their clients are advanced, but that can't come before the duty to the court to be candid. That obviously is your fundamental touchstone when bringing judicial review proceedings. Moving on then to another issue that frequently becomes a point of contention in judicial review cases, the time limit. I mean, this might be JR 101 for many of you, but the question that I'm essentially asking is, what is the deadline for bringing a judicial review claim? Many people, perhaps lazily, say it's 3 months, isn't it, from the date of decision? It's not. I'm sure most of you know that, but it's important to emphasize it's promptly and in any event within 3 months from the date of decision. I've encountered those that perhaps misunderstand and think that it's from the date at which the person affected by the decision learns of it. That's not correct. Or they think it's from the date the decision was sent or the date the decision was received. It's the date of decision. If the person affected by the decision only learns of it at a later date, that's something that's plainly relevant to applying for an extension of time. But it's the date of decision, and it's promptly. So the 3-month backstop is there, but it's promptly and in any event within 3 months. If there is undue delay, permission can be refused. And I've seen over the course of my career a few instances of where the upper tribunal has refused permission, even when the JR claim has been brought within 3 months. There is a rebuttable presumption that if the claim is brought within 3 months, that it's been brought promptly, but clearly that presumption can be rebutted. So if there's undue delay, or if there's a sense that the individual affected by a decision has not acted with urgency, then the court does have the power to refuse permission on the basis of the claim being brought out of time, even if it's within the 3-month period. If your client finds themselves in a situation where they are out of time, he or she can apply for relief from sanctions, so essentially for an extension of time. But it is imperative that if you think there's a timing issue, that you address that issue as part of the claim. I wouldn't leave it in the air hoping the court will perhaps not notice it or think that the court can deal with it without you having to address it. You need to make a formal application as part of the claim to extend time. The test to be applied is the test in the case of Mitchell, and then reiterated in the case of Denton and White. It's been looked at within immigration context in many cases, but the most notable one is the case of Hysaj. And essentially there is a 3-stage test. The first step is the breach trivial? Sorry, I think I need to move to get these lights working. Hopefully that's going to kick in. Is the breach trivial? If the breach is trivial, then the court will usually grant relief. What is a trivial breach? I've always taken a very cautious approach, and I've thought that if you've missed the deadline by more than a day or two, and you don't have a good reason for missing the deadline, then that is probably not a trivial breach. It's not a significant breach either, so you can try and place it within the spectrum. But clearly you need to address whether the breach is trivial or not. If the breach is found to be trivial, then you'll normally get release, so you'll normally get an extension of time. If the failure is found to not be trivial, then you as the person asking for relief from sanctions needs to persuade the court to grant relief. You'll need to give a reason for the breach. So why was the claim brought out of time? If the court finds that the reason is a good reason, then the court is likely to grant relief. I mean, just thinking off the top of my head, a potential good reason might be where somebody had been planning to file and then because of COVID was unable to. But these days, obviously, with being able to file by email, that might not be found to be a good reason. You need to identify whether or not there's a good reason. And if the court finds that there was no good reason, then looking at all of the circumstances of the case, is it appropriate to grant relief? Is it in the interests of justice to grant relief? We always return, obviously, to the same principles there. I found that where you go through this three-stage process, at the very least, you're assisting the court in understanding why you're asking for a relief from sanctions. It shouldn't be a particularly complex application to make. And bear in mind the duty of candor. It's important, all cards on the table. If there is a reason, but it's unlikely to be a good reason, it's better to just hold your hands up and say, look, I acknowledge this is perhaps not going to be accepted to be a good reason, but look at all of the circumstances of the case. Perhaps the rights of a child are affected. Perhaps the underlying claim is an asylum claim, and bring forward your best points, but follow this three-stage approach. In terms of examples of where it might be found that there's a good reason to extend time, pursuit of an alternative remedy. There's quite an interesting point of law that I don't think has been fully considered by the courts to date, and that's the question of admin reviews. Clearly, you have a decision refusing leave. You have an alternative remedy in the form of an administrative review that you should follow. And then once the admin review is decided, you can judicially review both the underlying decision and the admin review decision. But when does time start in terms of the original refusal decision? The Home Office policy guidance says it starts from the date of the admin review decision. But I think looking at the authorities, the older authorities, and taking a very strict view, it's arguable that the first decision is a decision that if you want to JR it, you need to bring the claim within 3 months, or you need an extension of time to challenge it. Now, that point has yet to be considered by the courts. Certainly, I'm sure that the courts will say in any event, it's a good reason to extend time because you were following an alternative remedy. Entering into negotiations with the other side. There's case law that suggests that that is potentially a good reason. I would urge clients not to take a risk. And if you're still negotiating, but you're coming close to the 3-month backstop, that you should lodge in any event. Awaiting a test case, again, there's authority that says that could be a good reason. Again, I would say better to lodge, apply for a stay, provided that you have sufficient details about the case you want to be stayed behind. Time spent awaiting legal aid funding is not generally a good reason to extend time. So that was considered in 3 cases that are now quite old, cases of HISAD, Keegan and ZP. If you really need to try and make an argument that there were funding issues that led to delay in filing, what I tend to place reliance on is the ability of the person affected to bring the claim on their own. So if English is a language that they can't use, if they have vulnerabilities that mean that they wouldn't be able to do it without legal assistance, then pray those things in aid and see where you go with them. But there is authority that says time spent awaiting legal aid funding is not generally a good reason to extend time. The importance of the pre-action process. Again, I'm conscious this is something that you'll be doing on a daily basis, and I don't want to go over things that are simple, but it's really, really important that we emphasize that the pre-action letter serves an important purpose. What it does is it tells the Home Office in the immigration context very clearly the decision that's being challenged, what you say is wrong with the decision, and what you would like them to do about it to avoid having to go to court and then them having to bear your costs. And if you're clear about those things, and if you're persuasive about those things, you can sometimes obviously avoid litigation, but you need to act in good time. You need to comply with the pre-action protocol and give the Home Office sufficient time. So 14 days in a normal case, obviously shortened time in an urgent case. And it's relevant then to the issue of costs, because if you put it all in writing to the Home Office in a pre-action letter, and the Home Office doesn't give you what you ask as part of that process, but then at a later stage, after you file a JR claim, they concede, you're more than, you're almost certainly going to get your costs. And if you win at the very end, it's going to be relevant. The court's going to look at your conduct overall. And again, if you put it all up at the front, it will help you get your costs. So it's very important that the protocol is followed. The pre-action process can also be really helpful in terms of getting information or disclosure from the Home Office. So for example, in cases where your client has been interviewed, but you've not been served, or your client hasn't been served with an interview transcript, it's a great way of requesting the interview transcript. And on that note, let's move on to the topic of disclosure. Because of the duty of candor, the courts do not generally order disclosure. So the principle is, because you're expected to disclose relevant evidence just as a matter of course, that there's no need for the court to get involved in the issue of directing parties to disclose certain things. But clearly, the other side might not disclose what you want them to. That can be useful in the long run in terms of asking the court to make adverse inferences from the failure to disclose. But you also should be active, dynamic about it, and apply for the Home Office or the other side to disclose the documents that you seek. You'll be saying to the court, JR is supposed to be a flexible process. In this case, the interests of justice require that this document or these documents are disclosed in order for the claimant to have a fair hearing. And I've had cases in the past where we've sought disclosure, and as part of that, the Home Office have ended up conceding. They go back and they look at GSID case notes, and they realise actually, when you look at what's on the Home Office records, the Home Office case can't be made out. More often than not, the Home Office will also be complying with its duty of candor. So you have to remember that it goes both ways. Another issue about, or that touches on this idea of JR being a flexible process, is the calling of live evidence in judicial review proceedings. The general rule is that judicial review is not the appropriate forum for deciding disputed facts. But building on that, cases like the case of McVeigh have established the principle, it's the basic principle, that if there has been no live evidence, if there's been no cross-examination, then the defendant's evidence, so in our case, the Home Office's evidence, will be assumed to be correct. So if we wish to dispute anything about the Home Office's evidence, we need to be making applications to cross-examine or to call live evidence. I think in the course of my career, I've probably made 10 to 15 such applications. Half of them have been successful. I think I've cross-examined in JR proceedings about 6 to 7 times. Often it's in the nationality context. So in cases where there's a factual dispute about whether the individual is actually entitled to a British passport, or is in fact a British citizen or has an entitlement to British citizenship. And that's where JR can work, where we have a cross-examination, where we have live evidence. At the same time, it's almost a tactical thing that you're doing as well, because you're letting the court know you don't accept what is written in the Home Office evidence, that there's a factual dispute here. And if you don't do that, I've certainly had it that the Home Office will just rely on the principle from McVeigh, that because there's been no dispute as to the factual evidence, then the defendant's evidence is assumed to be correct. Moving on then to another perpetually hot topic in judicial review, and that's the topic of interim relief. Now, I know that this normally arises in the removal context, but don't forget that applications for interim relief can arise in any judicial review. You could make an application for interim relief on something such as confirming that an individual can continue to have the right to work until a judicial review claim is concluded. So although we normally, I think, in run-of-the-mill cases deal with it when it comes to preventing somebody from being removed from the UK, interim relief is obviously something that can arise in a different context as well. We'll come on to deal with, I suppose, the threat of being hauled before a Hamid court or being accused of doing something wrong when you make applications for interim relief in a moment, because that's, I suppose, another theme that really permeates through this presentation. But do remember that you have an enhanced duty of candour if you're going to be making an application ex parte, so without the Home Office being part of the proceeding. So often when you bring applications for interim relief, the Home Office are party to the proceedings. If you end up having to make an application either in person or on the telephone to try and get a stay, for example, a stay on removal, sometimes the Home Office isn't represented. You have an extra duty to ensure that if there are things that you know that perhaps undermine your case, they are placed before the court. That a clear note is taken of everything that happened, because the other side might be within its rights to request a note because they weren't there. So it's essential that you always remember the duty of candour. And I know you will, but it's also essential that you remember what it is the court is actually dealing with. It's, again, harking back to law school, the balance of convenience, the American Cyanamid test. You need to persuade the court that if they don't grant your client interim relief, the effect on your client would be far worse than any negative effect on the Home Office. So again, in the removal context, that's normally because you're saying here, the client will be removed from his family, from his social network, to a country he may not have lived in for a long time, where he might be at risk, whatever it is in your case. Whereas on the other side, although there will be perhaps a loss of money to the Home Office, certainly inconvenience, and I suppose I've seen it argued an undermining of the public confidence in the removal system, you weigh those things up and the effect on your individual client outweighs, at least at the interim stage, any negative effect on the Home Office. But that's what you're grappling with when you're making that sort of application. So again, turn your mind to the basics, to the basic legal principles. Use the right forms. Again, I know it's obvious, but sometimes people don't use the correct forms. So it's a T483 if you're applying for urgent consideration at the same time as issuing the claim, and a T484 if the claim has already been issued. In a removal case, comply with practice 5, forgive me, part 5 of the JR, of the Upper Tribunal JR practice direction. I mean, you're supposed to tick the part on the form that says that you have complied, but make sure you're actually complying with it. You need to be able to explain why you have done what you have done when you've done it. So when did you learn of the imminence of removal? Why didn't you do anything sooner? Invariably, it's because you were liaising with the Home Office and hadn't heard back, and you were hoping that you didn't have to bring a claim. It's also important, perhaps again, just going back to a basic principle to reiterate, you need something that's susceptible to judicial review. You can't just make an application for interim relief unless there's an underlying JR claim. So what are you challenging? The failure to cancel removal directions, or perhaps certification of a human rights claim, and then you also want to challenge removal in that context. Don't forget, some of these basic principles. And then, of course, we have to always confront the risk that if we get things wrong in this jurisdiction, we leave ourselves open to potential sanction. We could find ourselves brought before a Hamid court in the Upper Tribunal and have to explain why we have done what we've done. And some very good lawyers have been brought before Hamid-style courts. It's, I suppose, an occupational hazard. But the reason that we're reflecting on a lot of these principles is to make sure that we're doing everything to the best of our ability, making sure that we're not making easily made errors, and that we're constantly live to the risk of being brought before a Hamid court if we get it wrong. I'll return to that issue in the final slide. You've probably seen that I'll look at one particular case. Now, a sort of catch-all slide, and forgive me that this is being covered in a sort of haphazard way, but there are, again, some important things that I think it's important to reflect on, and perhaps hopefully be useful for us all. The first is the judicial review bundle. I mean, we prepare these again on a daily basis, but it's sometimes worth pausing and thinking to ourselves, what's the purpose of the judicial review bundle? I mean, you're sat there as a judge, you've probably got a heavy workload, and the last thing you really want, if you're past a judicial review claim to determine, is a huge bundle with loads of irrelevant information in it, nothing at all in, you know, a useful order, pages and pages and pages of policy guidance that just aren't relevant. So let's start with the basics. We need an indexed and paginated bundle, essential reading clearly marked on the index. You want the bundle to be in a clear, logical order, so chronological order probably, or thematic order with a bit of chronological order in there too. You want all the decisions that are being challenged, not just one. If you're going after both a main refusal decision and an admin review decision, both of them need to be in there. Historic decisions that might also assist, but clearly marked so the court doesn't get confused. Relevant correspondence, so relevant pre-action correspondence. The evidence that was submitted in support of the application in question, that's really important. And here there's a very, very important point to make. And again, I apologize, it's a fairly obvious point. Don't include evidence in the JR bundle that was not before the decision maker. If it's fresh evidence, it shouldn't be part of the JR. It can form part of something else like a further application, obviously, but it's not relevant to the judge making the decision. I've had it said by an upper tribunal judge in a case that what one can do is mark clearly where the evidence before the decision maker was and where the fresh evidence is in the bundle. But my own view is the fresh evidence shouldn't be in the JR bundle at all. It just confuses things. And as I said, returning to things like to the principle of the duty of candor, other documents like previous determinations, etc., they should all be in there. The last thing you want is a court having to make a decision without all of the facts in front of them. Then moving on to amending JR grounds. Now I have to apologize. The case citation I've included there is in fact the upper tribunal version of SPAHIU. There was then the Court of Appeal decision in 2018. The reference is 2018 EWCA Civ 2604. And in the Court of Appeal, in fact, you need to apply to amend JR grounds, the Court of Appeal said, any time after your case has been served on the Home Office. So it's not just before the acknowledgement of service. So it's incredibly important that if after you have filed your claim and filed your grounds, if the arguments change or develop, you need to be making an application to the court, paying the appropriate fee and amending grounds. And there's a prescribed way that you have to amend grounds. You don't just put in new grounds, you actually physically amend the old copy of the grounds. I learned that to my dismay once when I was in the upper tribunal in my early days of practice, and I had a judge tell me, next time make sure you follow the appropriate way of amending grounds. And you look in the CPR and there are rules on this. At the time I didn't know that. You're supposed to use certain colors when you're amending the first time, and if you amend again, different colors. There's a whole color coding system. So make sure you're following those rules, because not only does it assist the court, it goes back to that point I made about procedural rigor. And the court will be live to those sorts of issues, as I've certainly found in my career. But you need to be applying to amend grounds. Again, it's an obvious point. If you want to run a new ground, if you want to change the way you're putting the grounds, you need to make an application. If you're renewing an application for permission, you also need to be really live to two things. The first is you need to put in separate renewal grounds. It's not enough to put in a note on the renewal form, or a one-page document saying we rely on the previous grounds. You need to actually deal with the reasons for refusing permission. And the second point to make is you're not then running new grounds. You have to be very careful that when you're putting in your renewal grounds, you're not running new grounds. So there's a delicate balance to be struck there, but it's important that you're following those two principles. There is a sense, having outlined all of that these rules don't apply to the Home Office, because the Home Office can, of course, issue supplementary decision letters. In the case of Karupan, the Court of Appeal said that there's nothing inherently wrong with supplementary decision letters. if you're in a case where you're faced with a situation where the decision you're challenging is clearly flawed, the Home Office puts in a supplementary decision letter that is, supposed to cure the deficiencies in the letter that you're challenging. Remind the court that if your client is going to suffer some sort of unfairness in seeking to defend, or seeking to challenge the amended or the supplementary decision letter as part of those proceedings, that you can raise that. The key thing is there going to be any unfairness to your client? But we've all dealt with certain judges that perhaps look at the supplementary decision letter, realize that it deals with the deficiencies and think, well, materiality, JR is a discretionary remedy and that's that. But it's something that, again, we have to deal with and we have to be live to. Consent orders, they serve an incredibly important purpose. I'm sure that none of you are the kind of lawyer that when you get the Home Office consent order, you say, oh, great, they're giving in, sign what they give you and send it back. You should always be looking to see if there's scope to amend the consent order that's been proposed by the other side. You can use the recital to sort of box the Home Office in on things like how long it takes for them to consider or reconsider the decision, the scope of that reconsideration, whether that's considering further evidence or the date, the date at which the evidence that's already been served will be considered, whether the Home Office accepts the fact that Section 3C leave is, will be treated as having continued since the date of the impugned decision. All of those things can be addressed in the recital. And so it's incredibly important that we do give thought to how we're amending consent orders before we then agree them with the Home Office. And the other thing is argue over costs. I mean, there'll be the odd case where you think to yourself, right, I don't think we're going to get our costs back, but fight for your costs, fight for your client's costs. And if the Home Office won't agree your costs, then put it off to be considered on written submissions to the court. Again, I mean, that gives you scope through putting in written argument to actually get the costs that perhaps the Home Office will be unwilling to give you. So on the issue of costs, again, I'm hoping these are all relatively basic principles, but important principles that we need to ensure that we're getting right. So the general rule, winner gets his costs unless there's good reason to the contrary. But invariably, we will be dealing with cases where consent orders have been signed, and it's not always very clear who's won. So then we turn to the guidance in the case of M and the London Borough of Croydon. And you'll see that I've set out there in the final 2 bullet points the principles that were set out by Lord Justice Neuberger. So where there is partial success, the court will look at a number of factors. And looking at those factors, the court's starting point will be that there should be no order as to costs, but depending on what's occurred in the given case, will deviate from that starting position accordingly. So you might have a case where it's obvious that your client succeeded in the main, even though one ground didn't actually go anywhere. And there, I can imagine that the court might be likely to give your client costs. The court will obviously look at times where perhaps there's been an amendment of grounds, arguments have changed and give costs to a certain date, but disallow costs from an earlier date. So the key point to take away is, unless it's clear that your client has won, there will invariably be an argument as to why there shouldn't be no order as to costs, but it will be fact specific. Finally, let's move on to the cautionary tale of Mr. Ali. I'm sure you've all come upon this case both through reading things like the Law Gazette, trawling SDT judgments, and obviously there was a reported case, the case of Shrestha. And I'm always very reluctant to deal with named individuals, not least because when you weren't party to proceedings, it's difficult then to comment on them. But here we do have 2 judgments that we can read, and we can draw out from certainly the reported judgment in Shrestha, the key principles that arise from this cautionary tale. I mean, just very briefly, and I'm not going to spend too long on the facts, but here we had a solicitor that brought 36 judicial reviews, mainly where individuals making human rights claims to try and stave off removal. 11 of those JRs were found to be totally without merit. 9 of them were out of time. And the themes that were drawn out as being apparent in all of the JRs were that they were brought against decisions that were part of the pre-action process. So applications were seemingly being made under cover of pre-action letters. When the Home Office responded with a pre-action response, it was the pre-action response that was being judicially reviewed. The claims themselves were described as being very poorly particularized and badly drafted, with no clear arguable grounds being identified. When the JRs were refused and costs were found to be payable by the claimant, invariably applications were then made to the Court of Appeal. What we have here are just unarguable JRs being made against the wrong target, and the court was concerned and ultimately found that this was an abuse of the process. And the ultimate sanction in the end was a very large fine, having to pay quite high costs, and then a prohibition on bringing judicial reviews. This really is a clear example of why the court has the Hamid process. Although I know we often feel like it's there in the background, and there's a risk that even if you do things in good faith, you could still find yourself drawn before a Hamid court. Unfortunately, there are those that have abused the process or have been found to abuse the process. We're not those individuals. We have to constantly remind ourselves that as long as we're doing things in good faith, we're doing our absolute best to comply with the duties that are on us. And, you know, I was once taught that as long as you can explain why you did everything you did when you did it, and that explanation holds water, then you're fine. But don't forget that immigration law is an incredibly political area. We practice in that what's been described there in Shrestha as a difficult and demanding area of law. And there will be times where we have to, as long as we've done things correctly, stand up and, you know, stand up for ourselves and explain ourselves. There should be no shame in that, provided we've done things correctly. So I hope in the time I've been given in the presentation that I've just delivered, I've touched upon a number of the important parts of judicial review that interest you and that you'll find useful on a daily basis. As I said, I've got a few minutes to take questions, but otherwise, if you have more detailed questions, my contact details are there, and I'd be glad to answer questions if you have them at a later date. Richard, that's me done.
Jamil, thank you very much for a really masterful survey of this area, a very large area of judicial review, and compressing it so succinctly. But we do have just a few minutes, as you say, if any of the participants want to ask you a question. So please go ahead if you'd like to. It may be that people have had enough if they've been here since 10 o'clock.
Well, anyone's welcome to email me questions in due course. I'm always happy to answer emails.
Well, I think in that case, everybody, it's my pleasure as well as duty to bring this session of AstenJ training to a close, and I hope that you found it interesting and useful. And my thanks to all the speakers who've come along, having worked hard to prepare their course notes and then given of their time to give us these lectures today. And thank those of you who've spent so long today participating and viewing the training, and hope that you'll come to future training events. So for now, good evening and goodbye from me and from AstenJ. Goodbye.